Good afternoon. Welcome to Oral Argument. Before we start, we'd like to welcome 15 students from UC Berkeley School of Law viewing argument this afternoon. They're here with their professors, Cliff Gardner and Rudolph Alejo. Where are all of you? Nice to see you. Nice to see you. And your students, Mr. Alejo, welcome. Clerk may call the calendar.
Good afternoon. The Supreme Court of California hearing oral arguments in San Francisco on Monday, October 2nd, 2017 at 1:30 p.m. Case number S231260. The People, Plaintiff and Respondent versus Solma Marilyn Gallardo, Defendant Appellant. For Appellant, Mr. Christian Buckley. For Respondent, Mr. Noah P. Hill. Case number S224564. The People, Plaintiff and Respondent versus Leonel Contreras et al. Defendants and Appellants. For Respondent, Mr. Stephen T. Orton. For Appellant, Mr. Leonel Contreras, Ms. Nancy J. King. And for Appellant, William Rodriguez, Mr. Daniel J. Kessler.
Thank you.
Case number S175851. The People, Plaintiff and Respondent versus John Pierre Rices, Defendant Appellant. For Appellant, Mr. Cliff Gardner. And for Respondent, Ms. Alana Butler.
Thank you. In the first matter, the People versus Solma Marilyn Gallardo, we welcome the Honorable Brian M. Hofstadt, Associate Justice, Court of Appeal, 2nd Appellate District, Division 2. You may proceed when ready.
Good afternoon. May it please the Court. We are here today because the United States Supreme Court in Mathis and DeCamp provided the clear resolution that this Court awaited in McGee and found lacking in Shepard. The Court has now definitively stated that Apprendi applies to prior offense enhancements and that the Almendarez-Torres exception must be narrowly construed. The fact of a prior conviction means what it says. The Mathis Court stated that a trial judge, and I quote, can do no more consistent with the Sixth Amendment than determine what crime with what elements the defendant was convicted of. The Court went on to reiterate the core Sixth Amendment principle expressed in Shepard and DeCamp, that the Court may not look beyond the elements to the evidence, or to explore whether a defendant committed of one crime may also have been committed of another. Finally, the Court in Mathis stated the rule as such, that in fact the Sixth Amendment requires a certain level of indifference to how the crime was actually committed, and therefore a recidivist enhancement must be based only on what a jury necessarily found to convict or what the defendant necessarily admitted.
And so what does that phrase necessarily found mean?
Well, that appears to be the rub of the case, which is in fact the first issue I'd like to address, which is what I think the rule should be. It's clear that the majority of the United States Supreme Court in both DeCamp and Mathis would say that it is the elements and the elements alone. In fact, in Mathis, the Court actually said and said and said again that when it said the elements, it meant the elements. And I think that that's prescient because actually this Court in Alfaro and Finley and Krausen said the exact same thing, which is when we talk about what has been adjudicated, what we mean is what has been lawfully adjudicated, and that is in fact the elements of the qualifying offense. The Court has been very clear, the United States Supreme Court has been clear, much to the discontent of the dissenters, that there is no such thing as an extraneous fact or a non-elemental fact that can be held that a jury necessarily found.
But there's, I think as the separate opinions in Mathis make clear, there's some difference between a pure elements-based approach, like the one that the United States Supreme Court has taken in interpreting the Armed Career Criminal Act, and a question of what the jury necessarily has to find in order to convict, right? So, or at least there's debate about whether there can be any difference between those two things. So in Mathis, for example, the Court tells us that even when a particular statute lists different ways of committing a crime, some of which qualify as the generic offense and some of which don't, we have to undertake the further inquiry whether those are alternative means of commission of the same crime or alternative elements. Whereas the dissenters take the view that it doesn't really matter as long as the jury is charged with having to make a determination about one or the other. As long as we can say with some high degree of confidence that the jury had to find this particular fact in order to convict, that suffices. Do you have a view on which of these approaches is required by the Sixth Amendment?
Well, I certainly side with the majority opinions, which is always nice when you're the appellant. I think it is a fair question. When I was preparing for oral argument, I went back and read the concurring opinions and dissenting opinions because they often elucidate the actual issue that perhaps is dividing the court. And if I think in Mathis, the Breyer-Ginsburg dissent really is taking issue with the hyper-specificity that Your Honor is referring to. I don't know that it is fair to say, and I don't believe I've taken the position in my briefing, that we have to wholesale import the modified categorical and categorical. And I think it is fair to say that there are cases, perhaps under California law, where the means elements semantic difference isn't really the issue. I think as long as, and I go to actually Justice Alito's dissent in DeCamp, what Justice Alito actually said in that case is that so long as the jury necessarily found the fact, there is no Sixth Amendment violation. So it's interesting that Justice Alito, even in taking issue with the majority's specificity, is taking the position that no, under the Sixth Amendment, we can't go beyond what we can be certain the jury found. Now that raises the hypothetical question, which is, how does a trial judge do that?
But so even when you just use those words, certain the jury found, it's not obvious to me that that corresponds perfectly to elements of the crime. So imagine, for example, this doesn't happen very often, but suppose that a jury is asked to render a special verdict, and there's a specific blank on the form that says, did the defendant use a knife, right? That may not be an element of the crime. That may be a crucial fact to determine that an element of the crime is fulfilled. In those circumstances, would you not say that the jury found that the defendant used a knife?
I would, yeah, I absolutely would.
So that fits in your rule.
I think that it does. I think that we have to take a view of saying, and in fact, in Taylor, the court actually said, what should we look at? We should look at the jury instructions and the verdict forms. We should look to see how was this jury instructed and what did they find. So in California, for example, they may allege an enhancement, or they may allege a GBI allegation, if you would, and frequently you could have a special verdict. And so no, I don't think it would be fair to say in any respect that a trial court couldn't be certain that a jury found that.
How does your answer to that question translate to the plea context? You talked about something that a defendant necessarily admits. If a defendant, in this case, for instance, had been asked to allocute and said, I went up to the person, I used a knife, are we allowed to use that admission, even though it's not technically an element of the crime, but clearly there's no question that the defendant, in her own words, said, this is what happened?
No, I don't believe you can. And I think that's the rub of the issue, which is, and in fact, that really is the issue in Shepard, which is, what about extraneous statements? And the cases underlying Shepard really show that those types of discussions happen frequently at plea hearings. So in that particular case, I again think you have to look at what was charged and what is covered by the doctrine of collateral estoppel. I think
you would draw a line between extraneous findings by the jury and extraneous statements by the defendant?
I think that if a jury signs a verdict form, that is not extraneous. That is clearly litigated in the case. The defendant obviously had notice of that jury verdict form, and so it becomes non-extraneous. I think in this particular case, what we have is a plea to a 245A. In fact, it was a no-contest plea under People v. West, sort of the perfect storm, if you will, for a DeCamp case. So had she said, oh yeah, yes, I had a knife, or had the prosecutor said, well, here are the facts of the case, and she said, I plead guilty to 245A1, I don't think you can view that under the doctrine of collateral estoppel as having been necessarily adjudicated.
Why? Why is that, though? Because doesn't a trial judge in taking the plea have to have some assurance as a factual basis for the plea?
Well, frequently what occurs is the trial judge says, can I take judicial notice of a variety of documents, the police report, and what have you. The basis for that requirement is to ensure that the defendant isn't just admitting
Exactly.
a
And
made-up
so there
crime,
has to
right?
be some factual basis for the plea.
That is correct.
And why doesn't that map onto some notion of a necessarily found or necessarily admitted fact?
Because what is necessarily adjudicated is what is required by the crime that's charged. And so in this particular case.
But are you urging a necessarily adjudicated test or a necessarily found, necessarily admitted? I mean, these are all slightly different variants.
Well, I'm certainly advocating a necessarily adjudicated test. I think,
Not the language that appears in the cases, though.
well, it is the language that appears in Alfaro. It's the language that appears in Crossan. It's actually the language that appears in Mathis. The court effectively says if it wasn't necessarily adjudicated, then we can't do fact-finding about it. If we want to say necessarily found, to take the legal parlance out of it, my problem in the plea context is looking back. The question is, what was the crime? I think if we go fundamentally back to say, what is the issue the Supreme Court's addressing? The issue is that what we're trying to determine is what is the actual conviction, not what happened, not what the conduct was, not what may have been proven at trial or could have been proven at trial. It's what did Ms. Gallardo actually admit? What is the crime that she actually pled no contest to or guilty to? And so, regardless of what else is said in that hearing, the focus of a trial judge has to be in trying to determine the elements of that crime. The problem in a plea hearing, obviously, is most frequently, at least in California, we don't have a system where you stand up and you admit each of the elements of the charged offense. It would be nice if we did, because then it would take the place of this problem. What we have is a system where you stand up and you say, you've been charged with 245A1, how do you plead? I plead guilty. And you have a colloquy of your constitutional rights. So no, I firmly believe that any ancillary facts outside of the actual fact of the conviction, the fact of the conviction is what the court reiterates over and over and over again.
I'm still confused. I mean, what goes into the colloquy, then, in the taking of the plea? So in this case, for example, it says, assault with a deadly weapon or with force likely to produce great bodily injury, right? So that is the crime.
Well, in this particular case, we have no idea what was said at the plea colloquy. We have no record of the plea colloquy.
Okay, so is that the typical case, do you think?
Well, I can't speak to what is typically available in records on appeal. In my practice, typically in a plea case, you are provided on appeal with a plea form, with the plea hearing, and with probably the information or the complaint, depending on the phase of the trial. And the plea hearing could be any number of things. It could be short, and the defendant could say, I admit count one is charged. The judge could take the time to go through and say, here is the charge, here is the precise language of the statute. There's a wide variance in what happens in plea hearings, and frequently that variance depends a bit on the severity of the charges. And so if somebody's pleading guilty to first-degree murder with a special circumstance, that plea hearing may be far more extensive, where there's a back-and-forth discussion. Whereas in this particular case, we have a single-minute order with a single line. We have no plea colloquy. And so I don't know what was said. But even if what was said is, I plead guilty to 245A1, and the court said, well, what happened? And she said, well, I had this fight, and there was a knife, and I assaulted this person. That doesn't tell us what she just admitted. That tells us what she believed happened. Those facts aren't litigated. Those facts aren't adjudicated. What is adjudicated is what she admits. The record of conviction is the fact of conviction.
So you're saying that's all the more reason, especially when a defendant enters a plea, there's a whole number of extraneous things that come in, but they're promised a plea and they know what the sentence is, and so they have no reason to contest whether in fact a knife was in fact used or whether or not there was great bodily injury. And in fact, stipulations to factual bases and plea forms vary among the 58 counties. So you're asking for a rule that a trial court on review of the nature of a conviction, particularly serious or violent for purposes of enhancement, be, as you've indicated, necessarily found by the jury. And by necessary, you mean necessary to prove the elements of the charge, as well as necessarily admitted. And you mean necessary to the charge of conviction. So there might be extraneous facts, but those weren't necessary to the conviction.
That's correct. That is precisely what I'm advancing. And I think that's precisely what the majority in the United States Supreme Court has advanced in starting in Shepard, and certainly in DeCamp, and then reaffirmed in Mathis.
Could I stick to the plea context, though?
Yes.
So what is a necessarily admitted fact for a plea, then? If you say that as you say, if the defendant says, oh, I had a knife and we got into a fight and one thing led to another, you say that's not really, that's not an admission. That's just, you say, what the defendant thinks happened. What is a necessarily admitted fact, then, in that context?
Well, I think what...
Or a better way of putting it
Sure.
might be, what is necessary for the trial court to satisfy itself that the plea has a factual basis? That it isn't just the defendant standing up and say, okay, I'll take the fall for this crime.
Well, if I might, and I don't want to take issue with the question, so I'm going to try to answer it in two parts. The first part is what is necessary for the factual basis of a plea. In my experience, just about anything. So it's, can I take judicial notice of the preliminary hearing? Whether or not the judge ever reads the preliminary hearing, it's simply trying to make a record, right? My experience is that that's more about making the record than it is about any actual factual back and forth. I think probably the easier way for me to explain what I think is necessary is by pleading guilty to an offense, what precisely is the defendant admitting? In other words, what is subsumed within that guilty plea? And this court has stated what's subsumed within that guilty plea is the most basic elements of the offense. So that's where the least adjudicated elements rule came from, which is we don't assume it's the most grievous version of the offense. We assume it is the least version of the offense unless there's something else. So what is admitted, because frequently there is no admission, is take a case, not this case, where the defendant says, I'm guilty of robbery. What is covered by collateral estoppel? Well, you go and you look at the statute and you say, well, what is covered by robbery? Now, robbery is not a divisible offense, so it's actually pretty easy. You look at it and you say, well, this is what he admitted. This is what he's guilty of, because he admitted a robbery. So going all the way back to Krause and even Jackson, this court has said when somebody admits a crime, they're admitting the bare elements of that crime and nothing more. So the guilty plea to the crime is an admission of the elements that the statute subsumes within it. And so I think the fairest way to look at it isn't so much to say what did the defendant say in court, but what was the conviction, and then you work backwards from that. I'm not sure I answered that question or whether my statement was helpful in any respect. There were two other points that I intended to cover when I stood up, one of which is what should the remedy be in this case. And I don't think that the Attorney General and I have a substantial disagreement that the remedy in cases such as this should typically be to remand so that the trial judge can have a proper hearing looking at the documents to try to determine the conviction and not looking at the conduct of the facts. There have been other opinions that were published prior to this court addressing the issue here in Gallardo that talked about remanding for a new jury trial or remanding for harmless error analysis. I don't think the Attorney General is advocating for that. There are a variety of reasons, as touched on in the briefing, why that doesn't solve the Sixth Amendment problem. Not the least of which in California is if we have a new jury trial, we have a new conviction. So we don't have a prior conviction. We have a new jury making a decision about conduct that happened years ago. So it wouldn't qualify as a prior anyway. Beyond that, I think this court was very prescient in Guerrero and frankly in McGee by saying, you know, if we do that, if we go back and we litigate the facts, we open all of these other collateral problems of double jeopardy, speedy trial rights. What about changes of plea? What about jurisdiction, where we have facts from a Kentucky prior being litigated by a California jury in California a decade later? So we open up all these problems. I only raise that because it's something that has come up in some of the opinions that preceded that.
Could I ask,
Yes.
so is your answer the same essentially in the jury context too, which is that when there's a jury verdict and there's no special form or anything, the verdict simply means that the elements of the crime have been established.
Yes,
That's it.
that's it.
That's it. Is this point that you're making largely an epistemic one, by which I mean it is difficult to know? In other words, there are, in the abstract, necessarily found facts underneath the verdict, but it's just that we're not in a position to know what they are. Is that the nature of the argument? Is that there are these facts, but it's, in the nature of this inquiry, post hoc, later, we just can't know what they are.
Well, I think there's two parts of this argument, and actually the United States Supreme Court addressed that in the third justification. The first is the Sixth Amendment requires certainty. So the Almendarez-Torres exception, what the court basically said is facts about the prior are not certain enough. They don't have a jury verdict beyond a reasonable doubt. They are not cloaked in those protections that the Sixth Amendment afforded. And so, no, we can't go back and begin to try to unpack what we think the jury probably, maybe certainly understood the facts to be in order to reach the elements. I think what Your Honor is saying is that there may be many cases where there's facts that obviously the jury had to rely on to get to the elements. But those facts aren't being found. The elements are being found. I think the secondary problem, as highlighted by really the court in DeCamp more than Mathis, is how do you draw that line? How do we inform trial judges of how to go about that analysis? What do they review? How do they figure out, well, I need to really dig down in the facts of this case to see what I think this jury did? In Alfaro, this court very clearly said, the wonderful thing about applying collateral estoppel to the elements of the offense is finality. The defendant can't go behind him. The prosecution can't go behind him. It is a fixed in-time judgment. And therefore, a trial judge isn't required to go back and try to ascertain.
Your contention that there are no cases in which there is anything that, let's take your standard, which is certainty, right? You have to have certainty. I think that's what the cases say. So, are there no such cases like that? Assault with a deadly weapon, and the only evidence ever mentioned in the case is a gun. There's no mention of anything else. There's not a knife. There's not any other type of weapon. The only theory of the case from beginning to end is a gun. What do we make of a case like that?
Are you referring to a jury trial?
Yeah. It goes to a jury trial.
Sure.
Jury returns a verdict.
Sure. What I think the U.S. Supreme Court would say is you're absolutely permitted to go and look at the charging document. You're permitted to go and look at the jury instructions. You're permitted to go and look at the verdict forms. And so if in that particular case the prosecution charged assault with a deadly weapon, and if the jury instructions talked about assault with a deadly weapon, which presumably they would need to, because assault likely to produce great bodily injury is a lesser included of that offense. So in that particular example, the jury would need to have some direction as to what they're finding. I think in that case, certainly you have the finality that the Supreme Court requires. I think the difficulty here is to say what more can you squeeze into what Mathis and DeCamp require. And I think once we go outside the elements, it becomes very difficult to draw the boundary around the type of case. I think the classic example, and I'll give you the hypothetical, is what about a personal use situation where you don't have an aiding and abetting instruction given? That's the classical example that comes up in many of the opinions. So we infer, because there was no other defendant involved, and we infer because there's no aiding and abetting instructions, that the defendant must have been the one that used the weapon. So now we have personal use, which turns it into a serious felony. That may be absolutely true. And standing before you with a straight face, I can't say that it wouldn't be fair to say, yeah, I think probably the jury found that. But what the United States Supreme Court has said is we can't go there because the Sixth Amendment doesn't go there. That may well be true, but now we are making an inference, we're making a finding of fact about what the defendant did.
To be clear, earlier you said that special verdict, for example, that says, okay, note here, was this firearm used in a personal context, whatever, that's different from your perspective.
Absolutely. Absolutely. And that frequently occurs in cases that I have where The prosecutor is well aware that they would like this thing to be a strike downstream, and they're well aware that the bare offense itself, without some additional allegation, won't work. And so they do, in fact, try to get a special finding or an allegation.
I think the harder case is going to be the plea, and that's because they're so varied from county to county and how they're given and how much is given. And so what can a court look to and look at for a determination of whether or not the charge as the basis for the plea is serious or violent? Court can look to the minute order. Court can look to the colloquy, but the colloquy is almost always going to be vague, or we don't know what the defendant is actually admitting to. Even though there might be a mention of a knife, he's actually pleading to the GBI portion of a 245. What's a court supposed to do in that circumstance?
Well, I think the Shepard court uses the phrase, the conclusive records made or used in adjudicating guilt. The Shepard court goes on to say, you start with the statutory definition, you look at the charging document, you look at the written plea agreement, and you look at the transcript of the plea colloquy. And within those documents, if it cannot be determined that what was charged was an assault with a deadly weapon and what was pled to is an assault with a deadly weapon, then we don't get to use it as a prior. We don't get to work hard to change what it was into something we want it to be.
So the Attorney General mentions in his brief that it is not uncommon for prosecutors and defendants to agree as part of a plea agreement that the defendant will admit to a factor that will be necessary down the road to characterize it as a strike should the defendant return to criminal court. How should we think about those sorts of bargained for admissions? Do they count as sort of falling within the scope of the defendant's jury waiver?
I think that's a relatively complicated question, but I actually think it's more akin to a special finding by a jury. So if in fact that is the deal that was being cut, it would behoove the prosecutor to actually make that very clear on the record, which is, I'm only doing this plea deal because this is a basic assault, but Ms. Gallardo is also admitting that she used a weapon, and that's part and parcel of the negotiated plea agreement. I could see a case.
And why is that different from a situation where the defendant admits that on her own without a plea agreement requiring it?
Because it wasn't necessarily adjudicated. In your example, the admission to the knife was necessary for the adjudication. In other words, it becomes necessary for what occurred in the case.
Necessary in the sense that it is part of the bargain between the parties?
Precisely. We would not have had a plea agreement but for the reaching an agreement as to the fact that she's making that admission. And in fact, that is a substantial admission. It's covered in the penal code.
Is that the kind of necessity that the Sixth Amendment is concerned with? My understanding from Mathis is that the way that we think about plea stemming convictions is that we're not concerned with the jury trial because the defendant in pleading guilty has waived the right to jury trial. So really the fundamental question for a court down the line is figuring out exactly what was the scope of that waiver of the jury trial right, what fell within the scope of that waiver. And I'm not sure how your answer to the question about bargain for admissions versus non-bargain for admissions relates to that theory of bargain for convictions.
Well, I think in your particular example, you would have a direct record saying I'm waiving my right to a jury trial as to this charged crime and this specific factual allegation. You would have a waiver, so the waiver would apply to both those things. I think that's a very different situation than where you just have a guilty, well, in this case, a no contest plea, but we don't have any in that factual colloquy. I don't know for a fact that the United States Supreme Court would say that that's fine under the Sixth Amendment. My suspicion is that the debate is going to continue to go back and forth in the high court between elements and means and exactly what we mean by necessarily adjudicated. But I think that that case is far more likely to comply with the Sixth Amendment than a case where the defendant simply says something extraneous or fails to refute something that the prosecutor says, which has clearly been rejected. I am entirely out of time, including my rebuttal
No,
time.
you'll have 3 minutes on rebuttal, according to my clock. Thank you.
I will save those 3 minutes. Thank you.
Do you agree with your friend on the other side that the remedy is a remand for a court trial?
In this case, I believe that's the remedy, Your Honor. I don't think that this court is limited to fashioning a remedy of returning the matter for a court trial as opposed to a jury trial. A jury trial based on the record of conviction would satisfy the defendant's Sixth Amendment rights.
What about the practicalities of, I mean, you know, so part of what's motivating the limitations in Guerrero was concern that even if it doesn't actually raise double jeopardy or speedy trial problems, it would raise a lot of harms that are
It
sort of
would be
akin.
admittedly a cumbersome process, Your Honor, and seems like it lends itself more to a judicial finding. We still have 1025 of the Penal Code in place describing the roles of jury and trial court in determining these. Of course, if there is a jury trial right to a prior conviction, that would be a remedy. Now, and the United States Supreme Court has hinted that wouldn't cause any Sixth Amendment concerns. In Najawan, a case discussed in Discamps, one of the issues was whether or not after a remand, or excuse me, after an individual had been found to have suffered an aggravated felony for the purposes of a federal immigration case, and based on facts that were not elements of the offense, whether upon reentry into the United States, imposing additional time based on that offense would violate the Sixth Amendment. And the court found that as long as there was a jury trial extended to that individual on those new facts, that the Sixth Amendment would be satisfied. This remedy, as appellant noted, has been in some of our courts of appeal. Admittedly, there is a dispute, although those that have affirmatively considered it seem to have found that a jury trial right would exist. In this case, again, I don't think that remedy is necessarily warranted. I believe that the court can look to further information, the information in this case, any plea colloquy that might exist, any charging document, and make a sufficient finding regarding appellant's prior conviction. If I may,
Sorry, but so going forward, in terms of providing adequate guidance for other cases, what would you suggest that we say? That the court should first consider whether they can make the finding based on record materials concerning the prior conviction, and if they don't have sufficient information to determine that the prior conviction necessarily rested on the elements that make it a strike down the road, then at that point, a jury should be asked to make the determination based on sort of full presentation of facts about the underlying conduct?
I think as a rule of law, if this court were to find that there was a Sixth Amendment right in these situations, that it should simply say that, and that there would be a jury trial right. A defendant could, of course, waive that, as they often do, and then trial courts can make these factual findings as they do now. But as a remedy, the people are not opposed to simply remanding this matter for a court trial and not a jury trial. I think that the heart of this case appears to be the definition of what is a necessary finding, and what a jury necessarily finds and what a defendant necessarily admits. And it's important to keep in mind in this context that California's recidivist statutes are very different than the ACCA that was considered in Discamps and Mathis, which have been found to be elements-based categorical statutes as matters of statutory interpretation. California statutes, at least in part, are conduct-based, and certain things either don't align to any particular felony offense, or they are matters of conduct that can apply to any felony offense. And it's for this reason that if this court does believe that Descamps and Mathis counsel it to, as the United States Supreme Court did, avoid any potential Sixth Amendment concerns by narrowing the rule it articulated in McGee, we would ask this court to hold that a trial court can determine, in ruling on the truth of a prior conviction, whether or not a defendant has formally admitted a particular fact or a jury has necessarily found a particular fact. And there seems to be a dividing line between those facts, such as facts at issue in Penal Code Section 969F, which allows prosecutors to pre-qualify crimes as prior convictions. And it would be not an element, but a finding of fact that a jury is entitled to make. We don't seem to have any real disagreement that that would qualify as a non-elemental factual finding that is outside the rubric of Descamps and Mathis and would still allow a trial court to impose a recidivist sentence. Then there are the factual findings that are like the example of the reckless discharge of a gun. And we can determine that a jury found beyond a reasonable doubt necessarily that a defendant personally used that gun because there were no aiding and abetting instructions. And we believe that that type of finding is also sufficient for a trial court to find the truth of a prior conviction in California because these statutes are based on conduct and not on elements.
Counsel, you mentioned formal admission qualifies. What do you mean by that in the context of the hypos we've had so far? Is it we're specifically admitting this fact because it's part of the plea agreement and we know it qualifies for a strike? Is it enough if the defendant says, I used a knife? Is it enough if the defendant says, I'm fine with using the preliminary hearing transcript as the basis for the factual basis and the knife is mentioned there? What level does it become a formal admission?
I think it has to be not a stray comment during the plea colloquy, but part of the actual, part of the allocution to what occurred below. It definitely, the first example, Your Honor, that you used, whether or not this is a bargained for portion of the plea agreement, certainly if you're admitting something under Penal Code 969F, but also we believe that it's sufficient simply if this is a factual admission that brings someone within the reach of California's recidivism statutes. Keep in mind that the three strikes law has been around for over 22 years. The serious felony prior enhancement statute's been around for over 35 years. So appellate courts have counseled defendants for years to be careful about what it is that you're admitting when you are admitting a prior offense or when you're entering into a plea agreement because the facts have collateral consequences.
So you're suggesting that we should take a different approach with respect to people who are convicted out of state?
That does pose a different problem, Your Honor, admittedly. However, I think that individuals have notice upon coming to California and committing a new offense of what may be imposed based on the nature of their prior admissions or their prior convictions and what facts were found by a jury or what they pled guilty to. So I don't believe that that would be necessarily problematic.
It seems unusual, to say the least, that the effect of a prior admission would be affected by a decision to cross state lines.
I'm sorry, Your Honor. Could you repeat the question?
Well, the notion that an admission that may have been made against one legal backdrop for one set of purposes might take on a completely different legal valence just because the defendant has made a decision to cross state lines seems like an unusual proposition.
Well, I think that these are not admissions that are inconsequential in and of themselves, generally speaking. The use of a weapon, the the infliction of great bodily injury to the extent that these were things that were alleged in a foreign jurisdiction and admitted. I don't think it would violate notions of fundamental fairness or the Sixth Amendment to say that these are things that were necessarily admitted in the context of determining the truth of a prior plea. And to import wholesale this sort of notion that all we can look at are elements would do damage to the intent of the electorate and the legislature in enacting a conduct-based statute. It is true, and going back to Your Honor's question, that some of the language in 667B about foreign priors and in subsequent subdivisions talk about the elements matching in prior convictions, and this is language that's very similar to the ACCA. But you have to keep in mind that 1192.7 isn't comprised simply of elements. It's comprised of conduct. So if we can look to the conduct in California under those situations and under those factors, we believe we should also be able to look to the conduct from other cases. But what we're really talking about is a thin slice of cases where you can affirmatively determine what a jury necessarily found. And this is leaving no room for doubt concerning a fact that was established in a prior proceeding. I would like briefly to touch on waiver, if I may. Appellant personally waived her right to a jury trial in this case. And if the intent was for appellant a jury trial as to the prior convictions in this case, and if the intent was simply to waive a state right, there was no need for a personal waiver. That could have been done simply by counsel waiving right to jury. The waiver in this case, to the extent that the Sixth Amendment allows or prohibits the type of judicial fact-finding that appellant objects to on appeal, waive that right. Counsels in the Court of Appeal relied on the exact same cases that existed at the time of the waiver. There was no intervening law that came out. It was Descamps and it was McGee. And to the extent, and I would point out that this court in French has found that when there is a time of flux over apprendi, that it's sufficient to take an express waiver of a defendant's right to jury trial.
How do you think that we should consider changes in the law since the waiver was entered in analyzing whether the waiver is valid, if that's what it is, or, the forfeiture, actually?
Well, I think that the relevant question is what was the law at the time that it would have allowed the individual to make the objection. Now, certainly, admittedly, Mathis has come out since, although it says substantially what Descamps says and doesn't elucidate the issue to any great degree. There have been lower court holdings, but those also certainly don't trump anything that Descamps said, and that's the core of the issue in this case. So to the extent that there was some sort of a right, we would ask this court as to this defendant to find that that's been waived.
Isn't there also the possibility that what she was waiving was the right to jury trial as defined in Section 1025?
Certainly, Your Honor. There is a very limited right to a jury trial under 1025, and
isn't that, given the way that, as I understand it, this issue, the larger Sixth Amendment issue, and the fact of the Supreme Court's decision in DeCamp was not a focus of conversation in the trial court. So it makes it a little bit difficult to think that what defendant was doing was anticipatorily waiving any Sixth Amendment right that might be recognized by this court in light of the U.S. Supreme Court's decision in DeCamp and its progeny.
No, but scores of courts of appeal, or at least a few courts of appeal, have published this cases holding just that without this court's guidance. And appellant herself raised these issues without these courts' guidance months later in the Court of Appeal.
Certainly. I mean, so I think that what that means is that she could have raised the argument in the trial court had she, thought to do so, and that raises a question about forfeiture. But that seems separate from the question of whether by waiving her right to jury trial in the trial court, she meant to waive any Sixth Amendment right that might subsequently be recognized, when that didn't seem to be what was on anyone's mind during the trial court proceedings.
And we have made a forfeiture argument that, of course, necessarily dovetails with a waiver argument. And for those same reasons, appellant didn't object to the trial court's factual findings. Her objections were essentially based on the evidence and what was considered, the scope of the evidence to be considered, not the constitutional competence of the trial court to make those findings. So we would ask this court, to the extent that it does believe that the discussions in DeCamp and Mathis require it to change California's rule in McGee, that it would have trial courts make determinations of the truth of prior convictions based on facts that were necessarily established by a jury's verdict and or necessarily found and admitted by a defendant during a plea agreement. Thank you.
Thank you, Mr. Hill.
With the time I have remaining, very briefly, I addressed the Attorney General's forfeiture claims in the briefing, and I won't repeat them here. It is worth noting that the Attorney General violated Camacho. Mr. Hill decided not to raise the forfeiture claim until we arrived before this court, which of course is precluded. Had he chosen to litigate that in the Court of Appeal, we may have had an appellate decision on that subject, which would be before this court. So it is improper for the Attorney General to wait to arrive here to somehow claim forfeiture, not mentioning the fact that McGee obviously is controlling, and under auto equity, it is not as if a trial judge was free to range away from McGee. And the record's very clear that this trial attorney objected on any basis he could find to this trial judge considering the plea hearing. So the notion that there wasn't an objection or that somehow a claim of insufficiency under the Sixth Amendment is forfeited, I think is not accurate, and frankly not even before this court. My dad once told me or taught me that the art of advocacy is simplicity, and so with the 2 minutes I have left, I want to try to be plain and simple in the position I'm advocating. The first of which is, regardless of the rule sculpted by this court, there is no longer, under the Sixth Amendment, the ability of trial judges to consider the conduct or evidence in a case in order to enhance a sentence. DeCamp and Mathis clearly have done away with that. If that somehow runs afoul of California's three strikes rules, then the legislature is certainly free to change that. But the Sixth Amendment is what it is, and the Supreme Court has said what it has said. As far as the remedy in this case, number one, I think that remanding here would be idle in the sense that it's clear that this prosecutor supplied whatever this prosecutor had, and obviously the plea colloquy the preliminary hearing is no longer relevant to the consideration of what the conviction was. And so we would remand this case to a trial judge to pick up the minute order that's before this court and say, can I tell from this minute order that Ms. Gallardo pled guilty to assault with a deadly weapon? The answer is obviously no. So I think remanding for another hearing here would be an idle act. Beyond that, I just want to be very clear. The U.S. Supreme Court has not suggested in any respect that remanding for jury trials or affording a jury trial on missing elements somehow complies with Mathis and DeCamp. That's not in the jurisprudence at all. The reason for that, of course, is the Sixth Amendment violation happened back in the original trial, not this trial. And so we would be impaneling a new jury to do what? To look at the record of conviction and decide. I think the record of conviction shows that Ms. Gallardo was convicted of assault with deadly weapon, that right doesn't exist. That right still doesn't exist. In fact, much to Justice Thomas's disdain, Almendarez-Torres still exists. So in fact, there never is a jury trial right here in the present proceeding because there never is any factual analysis. And as I said just briefly before I sat down, a new jury trial would raise all kinds of issues, not the least of which is double jeopardy and speedy trial concerns. And as Your Honor pointed out, we would have a phenomenal difficulty saying, well, let's go back and pull out all that evidence from Kentucky and decide what that defendant did in Kentucky under Kentucky law by a California jury. I know of no jurisprudence that suggests that that is acceptable under either the state constitution or the federal constitution. So there never is a jury trial. This remains the same as it was in Alfaro. The judge looks at the record of conviction, decides what the conviction was, and it either qualifies or it doesn't qualify. Beyond that, there is no other issue litigated, therefore there is no jury trial. There never is a jury trial. With that, I would submit, and I thank the court for your time.
Thank you, Mr. Buckley. Mr. Hill, the matter is submitted. Calling the matter of the People versus Leonel Contreras, we welcome the Honorable Sandy R. Kriegler, Associate Justice, Court of Appeal, 2nd Appellate District, Division 5, sitting on assignment. Counsel, you may proceed.
May it please the court. Acting in concert, defendants committed multiple acts of kidnapping, forcible rape, sodomy, and oral copulation. If they were adults, the trial court would have sentenced them to terms of 200 and over 500 years to life. But the trial court considered their youth and instead sentenced them in accordance with this court's decision in People versus Caballero to terms that were within their life expectancies. Those terms of 50 and 58 years to life provide a meaningful opportunity for release, and therefore do not run afoul of the rule in Graham versus Florida. For purposes of today's discussion, I would like to begin by briefly addressing the term that the defendants will actually serve before turning to the limitations on categorical review under the Eighth Amendment, and finally considering the metric of life expectancies. Turning first then to the terms that they will actually serve. Recently, the CDCR has enacted a number of regulations that will substantially affect the terms that the defendants will serve. 2 years ago, when this court decided Franklin, it was the case that a defendant sentenced to 25 years to life would have to serve the 25 years before he would be able to be subject to parole or eligible for parole. That is no longer the case. Under the recent regulations, the defendants would be able to receive credits towards their parole eligibility, and those credits are substantial, amounting to close to perhaps in this case nearly half of the term, including good conduct credits, rehabilitation credits, educational credits, and what are known as milestone credits for completing certain classes. So the terms now that they would face are substantially less than the terms of 50 and 58 years. Nonetheless, I would urge the court to rule on the original question presented. And with that, I would turn to the question of categorical limitations on Eighth Amendment review. The starting point for this discussion is by necessity the decision in Graham versus Florida. And in Graham, the court highlighted two distinct and entirely separate doctrines for Eighth Amendment review. On the one hand, we have proportionality review, and on the other hand, we have review that's appropriate in capital cases. Review of individualized sentencing. Because the Graham court and Justice Kennedy concluded that the sentences at issue in Graham, LWOP, or life without parole, were the functional equivalent of a death penalty, the court concluded that the death penalty jurisprudence applied, and it was appropriate to enact a categorical rule. Thus, the Graham rule hinges on this notion that the sentence must be the functional equivalent of a death sentence. And to a juvenile, the court concluded that an LWOP is that functional equivalent. If a sentence is not the functional equivalent, and here, looking at the 50 and 58 years to life, those are not the functional equivalent.
So, counsel, I have a number of questions related to this. So, first of all, I just want to ask, as to your initial point, what would you have us do with these new regulations?
Well, I point them out because they are new, and I wanted the court to be aware of them. In terms of what I would have the court do, I think it's appropriate to consider the regulations, but I would also urge that the court reach the question that was originally posed.
So, your position is that 50 or 58 years to life sentences are not the functional equivalent of LWOP because the parole eligibility date comes within the expected natural lifetimes of these defendants, right?
Yes, Your Honor.
So, I guess the question you could anticipate is how much time need there be beyond the parole eligibility date for the dictates of Graham to be satisfied?
Well, Your Honor, I would apply the rule that this rule applied in Caballero, and looking at the life expectancy, that the life expectancy itself provides that meaningful opportunity. So we could even theoretically take it right up to life expectancy. If the life expectancy is as it is today, 77.1 year for these defendants, then we could take it all the way up to that age. And there is a reasonable opportunity for release under that. And to further answer the question.
Because you could be released a day before you die? Is that a day before you're expected to die?
No, Your Honor. The life expectancy is simply an average.
Right.
It's an average that's not even the median. And so when we talk about what's a reasonable opportunity, what is a substantial opportunity, taking something up to the life expectancy, which is something is a reasonable and meaningful opportunity. And
you're construing reasonable opportunity as meaning there is a chance you will live long enough to see that date. Is that what you mean?
Well, not simply any chance, Your Honor. I wouldn't say simply any chance.
A
substantial chance, which is what I believe.
50 chance.
Well, in truth, it's over 50-50, but and that's because, given this court's definition in Caballero, we look at it at an average, not the median. The median would be somewhat more than that.
Okay, counsel, suppose for a moment that I accept your gloss on Caballero and your framing of how averages matter here. And I take you to be saying not so much that the average is particularly great indication of how this particular individual is going to fare, but it's permissible for us to consider it. Under your understanding, would there be any situation where we would look at information that is even more specific and contextual? So about this particular kind of defendant who grew up in this neighborhood, who came from this particular background?
Absolutely, Your Honor. Those are questions.
If that information indicated that the life expectancy associated with this kind of individual, when you contextualize it, is much shorter, that would actually matter to the analysis.
It could. And that analysis is one that the Court of Appeal found it unnecessary to engage in the present case.
And when would you find it at least permissible and perhaps necessary to engage in that kind of analysis?
Your Honor, as I was saying, there are two distinct lines of authority under the Eighth Amendment. We have the disproportionality analysis and we have the categorical rule analysis. Under the disproportionality analysis, which is also akin to what we apply under the Lynch and Dillon factors of our state constitution, we look to a series of factors, including the nature of the offense and the offender as one of those factors. And so if, to answer with a hypothetical perhaps, we have a defendant who perhaps has been diagnosed with some form of a terminal cancer and has a few years to live, that would be appropriate to be considered in the nature of the offender, it would seem to me. Now, whether or not it's dispositive is a different question. But the original question that you asked was, could there be some point in which those factors are considered? And my answer is yes, but not under the discussion here today. Today we're concerned with the categorical prong, and the Court of Appeal never answered the question of disproportionality.
Can I ask you a question? I'm a little confused about why you want us to decide the case without regard to the regulations. I did some rough math last night, and it appears to me that, at least as to Defendant Rodriguez, he theoretically could be eligible for a parole hearing after 27 years of incarceration. Is that pretty close to what you come up with?
Yes, I mean, theoretically, perhaps even less.
So I assume the Attorney General's position is that the sentence in this case of 50 to life and 58 to life should be affirmed, right?
Indeed.
Graham leaves to the states the options of how to deal with the Eighth Amendment problem of LWOP for juveniles. We have the regulations. That provides what seems to me to be an answer to the Eighth Amendment issue. There are very few juveniles who are one-strikers. We're not talking about a large group of inmates in the situation of Contreras and Rodriguez. So why isn't it sufficient to resolve this case based upon the regulations?
I think that could be sufficient, Your Honor. We are here for the second time, of course. We were here previously on Franklin, and so this is a question that is likely to reoccur. And so that's perhaps one reason. A second reason is we also have the notion that the sentence in this case was not entirely authorized. We have mandatory schemes under the one-strike law, and the trial court struggled with this, trying to comport with the one-strike law on the one hand and Graham on the other. And the record demonstrates amply that this was something that all parties grappled with. And so it's something that the lower courts need guidance on as to how we apply the existing sentencing scheme with the requirements of Graham. And so guidance on that is still very useful.
Can I ask you, counsel, so you are giving us these life expectancy figures based on a CDC report looking at various age and gender cohorts, right?
Correct.
And so you suggest that we take gender into account.
Your Honor, that was the rule that this court announced in Caballero. It's a useful metric and a sensible rule.
I'm just wondering, I mean, Caballero didn't really decide that in the sense that we just made a comment in Caballero because Caballero involved a 110-year sentence, and under any metric of any life expectancy, that was going to not comport with Graham. But if we say gender here, why not race?
Your Honor, we're dealing with categorical rules. And the problem, as the High Court has recognized time and again with Roper, with Atkins, and indeed with Graham, categorical rules are not always satisfactory, and it's somewhat of the nature of the beast. We have to make decisions. In Roper, the court said 18 is the cutoff for when you can execute someone. Now, you have someone who's 18 in one day, and you may well ask, well, really, is that person any more?
Doesn't this raise a bunch of problems? So, I mean, I take it you want gender. I mean, forget about Caballero for a second. I mean, if we don't rely on Caballero, do you urge us as an original matter to take gender into account?
No, I don't urge the court to take gender into account. If I were deciding this afresh, I think that the approach that I would take is one in which is simply comports with the categorical origins of this rule. We all have some notion as to how long we will live. We don't typically consult actuarial tables, but we all came to work today, and we all thought, I'm coming to work because I'm hopefully going to live to see tomorrow. And we all have some idea of how long we're going to live. The actuarial tables are a useful metric. And to that extent, I would urge the court to abide by the rule that it set forth in Caballero.
Which aspect, I mean, this is getting kind of philosophical. Which aspect of the actuarial table would you have us use?
The approach that this court took in Caballero was to separate out gender and not apply race. And we do that, and it comports with this notion that we understand basically how long we're going to live. And it's simply a metric. It's a milestone, but it's not meant to be precise. What we're looking at is to give expression to the Graham rule as to whether or not the defendants can reasonably have hope. And that hope is defined by, here they are able to live within what is typically within the life expectancy.
And I know we're pressing you on something difficult perhaps, but reasonably have hope. Unpack what that word reasonably means in this context. If not to actually put a quantitative percentage on it, just say a little bit more about what that means.
Well, to unpack that somewhat from Graham, the court used a variety of different terms. It used the term some realistic opportunity at the end of the opinion. It used a meaningful opportunity at another part. And throughout the opinion, it expressed the notion that an LWOP would forsake all hope. The court was talking about, again, categorical norms of no hope. And when it expressed a desire to state a rule, it stated some realistic possibility. That's not, and I believe the court was trying to look for something more of a percentage-wise. But some realistic possibility is not saying a guarantee, as Amici would ask this court to hold. And of course, no one can guarantee that anyone will live for a given amount of time.
This is a very, I mean, I guess I'm grasping better how you're reading these cases, but how do you reconcile your reading of the cases with the other language in Graham that talks about rejoining society and reconciliation and being part of the community again and having access to vocational services and all these things? I mean, aren't these things in contemplation of the idea that someone is not only going to live long enough to see the outside world, but they're actually going to be part of the society, again, in an integrated way? That's not accomplished by releasing someone on the date before they're going to die.
Your Honor, there's still hope, even if we take it to the absolute extreme. There's still hope, which is what Graham is speaking of, because if we take it to the life expectancy, which is an average, if someone makes it to that average, they're not expecting to die tomorrow just because their life expectancy runs out. We're looking at the life expectancy now at 16 and saying that it's 77.1. If they reach the age of 77.1, their life expectancy is no longer simply 1 day, and it increases as they go along. What we're looking at is hope, and that's all that Graham required. And I understand that this presents difficult policy choices, but we're looking at Graham from the standpoint of a categorical requirement, categorical ceiling. And it's imperative, and to answer the court's question, it's imperative to Graham that there be an equation with the sentence of being tantamount to a death sentence. And Your Honor, you pointed me to certain language in Graham regarding rejoining society. There's additional language in Graham as well about that an LWOP and death penalty share commonality that are shared by no other sentence. And so while it's true that as we approach a very lengthy term of years, there are tough policy questions for the legislature. Those do not present questions under the Constitution, under Graham, because those two sentences, LWOP and death, are in a completely different realm.
I think you're right about that. I mean, in the sense that the court makes some, draws some analogs and adopt some of the framework reasoning that you're suggesting. But the further point about the reasoning of Graham, right, is, I mean, the further question as to why an LWOP sentence is impermissible for non-homicide offenders, I think relates to a set of broader concerns about what, as the court goes through in Graham, what are the possible penal justifications for such a long sentence, right? And the court rejects LWOP as plausibly related to these penal justifications. And that reasoning doesn't seem to me tethered to the notion that LWOP is equivalent to a death sentence.
Well,
that reasoning seems tethered to the notion that LWOP is a sentence that incarcerates someone in a fashion that never permits them to realize their potential as a human being, which is the whole notion of what this whole line of cases is about, that juveniles are not well-formed human beings. And so as a result of that reasoning, we limit their culpability, we limit the punishment that you can impose on them, because, as Justice Kennedy says numerous times, they have the capacity for change.
Your Honor.
It is not conditional upon the notion of equating LWOP with a death sentence. That's just conditional upon the notion that LWOP is a sentence that denies this fundamental possibility of juveniles, which has other implications for lengthy sentences.
I would of course disagree, and to the extent that Your Honor can read Graham in the manner that you have, I would refer the court over to Miller versus Alabama, where Justice Kagan specifically points out that it was this equation of LWOP with death for a juvenile that was so critical to the Graham analysis. And it is critical because, of course, Justice Kennedy, who penned Graham, also wrote the dispositive concurring opinion in Holland versus Michigan. And there he said, we're not going to incorporate individualized sentencing into our Eighth Amendment jurisprudence at all. And the only way for him then, when he penned Graham, to incorporate an individualized analysis was if he could equate it with the death penalty. But if we have a sentence, as we do here, that is clearly not the same as a death penalty, then Graham simply does not apply. And
Mr. Edding, can I ask you a question before you run out of time on your first initial presentation? And that is whether you can speak to, you spoke to the regs, and I know you raised the elderly parole program. Can you speak to that program and if in any way it affects this case?
Well, yes, I believe it would, Your Honor. And insofar as right now, Defendant Contreras is looking at age 60 for release under the elderly parole date. And
the elderly parole program is in regulation, not statute, and currently it provides for a parole hearing for an inmate who's 60 years of age who served 25 years. And that was imposed pursuant to part of the litigation in the federal consent order?
Yes, Your Honor.
And it's currently on the governor's desk by way of statutory form in AB 1448.
Absolutely.
How does that, if at all, affect this case, this outcome, or how we think about 50 years to life, or how we think about 60-year-old inmates?
Well, yes, and I believe here, as I pointed out, Defendant Rodriguez would actually get out even before he's subject to elderly parole. Mm-hmm. And that may also be the case for Defendant Contreras. He's looking at a parole date of right now about 64, just based upon the good conduct credits.
And that's part of the hope that you talked about and the meaningful opportunity for release based on demonstrated maturity and rehabilitation?
That is indeed. And with that, I'd like to reserve the remainder.
I just want to be clear. In your briefing and even in your presentation today, you're not urging us to rely on either the elderly parole program or the new regulations in deciding this case.
Well, Your Honor,
you're saying these are possibilities, but your first preference is that we simply address the question presented.
I believe that clearly, as evidenced by the record, that the trial courts do need guidance on this. And as I said, we're here the second time, and there are other cases, as the court is well aware. But this case, in order to resolve this case, this court could do as it did with Franklin.
Thank you, Mr. Eddy.
Good afternoon, Your Honors. Nancy King again, appearing for Leonel Contreras. May it please the court. Thank you for having us here on this. My colleague, Dan Kessler, and I both have a lot to say, and so he has permission to use the hook to drag me off when my 15 minutes is up. I think either of us can respond to questions the court may have, but our general intention is for me to address what we both agree is not permissible under the Constitution. And then Mr. Kessler will stand up and talk about what he thinks is a constitutional solution. Our bottom line here, I believe, is our clients have been denied a constitutional solution that the legislature came up with, and it's up to this court to decide what is appropriate for them under the Constitution. Speaking of Miller versus Alabama, a thought just popped into my head when Mr. Otting mentioned it. As it turns out, Mr. Miller is still waiting for a new sentence in the great state of Alabama. And
if we were in Alabama, that would really be helpful, but we're not. So could we move on to this case?
My point is the alternative, Your Honor, is that Alabama passed legislation for 30 years to life as an alternative, as a Graham solution or a Miller solution in that case. And states all around are coming up with solutions, and that's what Graham has asked this court or all the state courts to do.
So what are you asking us to do?
We are asking you to come up with a, hopefully better than Alabama, but we think that the same plan that the legislature came up with for pretty much most other defendants in this state where there is an opportunity for parole at 25 years.
So if we were to send this back for resentencing, what should the court do? Should the court set a new minimum that is at variance with what the statute calls for, or should the court impose a sentence that is consistent with the statute but make provision for parole review after 25 years? What should we do?
I think either of those is
Which one should we pick, Counselor? We have to pick one.
If I was deciding, I would say impose a sentence of 25 years to life. It's the simplest thing.
Okay, so that's the best it's got going for us? Is it simple?
It's certain. It creates certainty, which our clients don't have now, and neither do hundreds of other juvenile defendants. It's
Stand square with the legislature's authority to establish appropriate penalties in the legislature's evaluation for crimes, particularly very serious crimes of this nature. I don't think it's acceptable for us to completely ignore the nature of the behavior that brings your clients before the court.
Sure.
So I guess I'm voicing a little frustration with well, this is simplest, so let's do that, or this is certain, so let's do that.
Well, and I apologize, Your Honor. You asked me to choose, so I choose the one that makes me happiest.
I'm assuming, well, our job is not to make you happy.
Exactly.
Our job is to figure out what is an appropriate penalty under the statutory framework, and I'm giving you an opportunity to assist us in making that judicial evaluation, not your own personal preference.
Sure. The framework that the legislature did set up for other defendants, including murderers and gang killers and crimes that the U.S. Supreme Court has said are more serious than the crimes that our client committed. They set up a system whereby the courts are able to follow the statutory guidelines for imposing a sentence, but yet there is a possibility, or there is not a possibility, there will be a parole hearing after 25 years, maximum.
So under that analysis,
I think that's a fair outcome.
All right, so I appreciate that it's not the one you want.
Oh, I
But
want it. I'm happy with that.
All right, but at least if we were to say, I mean, we have to send this back to the trial court if you persuade us and tell them to do something. And I'm casting about for what we should tell them to do. And I'm hearing you say, so correct me if I'm hearing it wrong, is that one way to skin this cat is to send it back to the trial court, say, impose a sentence that is consistent with the statute, however, require that there be a parole eligibility hearing after 25 years.
I think that would be acceptable. As it turns out, in our particular case, it could just be remanded as is, and the terms could be imposed legally under the statute. The terms could be imposed concurrent and
How
get
is
to
that
that
legal?
25 years.
These are all mandatory consecutive sentences.
Let me back up,
What
Your Honor.
what is the source of that power? Is it the Eighth Amendment? You can't do this because it violates the Eighth Amendment?
That was the source for him imposing the 50-year to life, and so I think that would be the source for imposing. And I misspoke. You're right, Your Honor. Under the multiple victims.
So would you rather have 640 years to life with a court-ordered parole eligibility at age 55 than what you have now? Would that satisfy the Eighth Amendment?
I don't think so, because I don't think there's anything in Graham that contemplates a geriatric solution to this problem. There's nothing in there.
As I understood your answer was impose by judicial fiat a parole hearing after age 25 for these defendants.
After age 25?
After 25 years of incarceration.
That was my point.
Okay?
Right.
So what if the court were to say 25 isn't enough? The legislature's rejected that repeatedly. We think it should be 45 years. At that point, could the court impose the full sentence that the legislature requires for Contreras, 640 years to life, but by judicial fiat say give him a parole hearing after 45 years of incarceration? Is that one possible remedy?
It's not the best remedy, I don't believe, but it is a possible remedy. I
But
think
wouldn't that afford him a meaningful opportunity for release in his lifetime? And wouldn't that satisfy the Eighth Amendment?
that's what we're looking at, is that parole opportunity. That
If it's not
possibility.
25 years because the legislature has rejected it, what is the appropriate measure? How are we supposed to decide that as a matter of law?
As a matter of law, the language in Graham nowhere talks about a geriatric release. In the new elderly parole program that the courts talk about, or that's sitting on the governor's desk right now, if that goes through, and if not, there's still the similar program. They talk about, right up until a couple weeks ago, and they've talked about it throughout the entire process, starting last spring, that age, excuse me, I've got it right here, that it's presumed, it's overwhelmingly presumed that age 50 is the point at which prisoners are considered to be elderly, presumed to be geriatrics. And that's the presumption in the legislature right now.
That is.
Pardon me?
What an unfortunate selection that is.
I think so.
Geriatric?
That's the overwhelming assumption of
describing a population of people that have been imprisoned for their adult lives.
and that's describing our
But
clients.
that's not
and-
describing the general population.
No.
Right.
Right.
So wouldn't the better part of prudence here be, given the state of play, I mean, there's been mention of regulations, there's been mention of pending legislation, there's been mention of guidelines that haven't been codified. Wouldn't the better part of prudence here be to simply focus on the sentences at issue here and say, all right, your position is they're unconstitutional. They're unconstitutional. And the trial court should be instructed to go back and pronounce a constitutional sentence, just as we did in Caballero, by the way, without giving any guidelines. And given the soup of moving targets that exist in this environment, the lower courts will struggle through it. But it's not really the most opportune time for this court to devise a hard and fast rule in light of all the other activity going on. This is not an issue, in other words, that is not getting legislative attention. It is. And so a solution may be in the offing. And so it need not fall on us at this particular juncture to develop some kind of hard and fast rule. Especially not one that's 25 years, simply because the legislature has already said that's not our view. It puts us in a very uncomfortable position to directly countermand the legislature's judgment.
I think I don't disagree with you that it can be stewed around for a long, long time in the lower courts.
If you were to prevail here and these sentences were vacated, then you would go back to the trial court and you'd be making some different points, actually, because you'd be talking about things that have happened in the environment, legislative environment, since actually the first sentencing. And that would go into the trial court's consideration, presumably, and you'd get some different arguments made. And that's how the law develops.
That is how the law develops. I think the point that I'm concerned about, that we're concerned about, is that our clients and clients that are in the same position as our clients are entitled to some certainty. Everybody's entitled to some certainty, and there's no indication that there could be a rule like the one that I suggested to you, Justice Corrigan, about you can give them any sentence you want, but we need to give them a light at the end of the tunnel, and it may be an arbitrary 25 years, but that's one that leaves them with a possibility of getting out, or possibility of a parole hearing. We're not even talking about release. We're talking about parole hearing while they're in their 40s.
This is a hard case, and I understand the difficulty, but when you mention 25 years to life, we know that the legislature has rejected that. First of all, they excluded one-strike offenders from 3051 LWOP 25 a year to life parole hearing. And one-strike offenders are heinous sex offenders. As Heard already said, this case is worth 640 years if these young men were 2 years older. And so we need not only certainty for them, but even the trial court struggled in this case, knew that it couldn't give 640 years, said, what should it be? Worried that we would hand down an opinion that said, figure it out, and then tell them again it was wrong. So we know that the legislature has rejected 25 years to life and that hearing for these kinds of sex offenders. So then it shouldn't be 25 years to life that this court says, and we're not in a place or a position, frankly, to pull a number out of the hat. That is a more legislative decision. And so the trial court has to act. This case will go back to this trial court and many other trial courts. We're required to give them some guidance. And if we agree that Graham, which addressed LWOP for non-juvenile homicides, if we agree that that even applies in a term of year sentence as here, then if it's about hope and a meaningful opportunity, then I don't understand why the regs with credit, good conduct credits, don't give you hope and don't give a person incentive to demonstrate good behavior in order to earn those credits to be out in 27 years, or why hope isn't at 60. It's hard for me to fashion something that the trial courts can understand and impose.
Okay, I'll speak to that real briefly because I know I've used up my time. Under the regs, I call them the Prop 57 regs, that give them the opportunity for good conduct credits and so forth. I don't believe that gives them the kind of certainty that we're looking for. The conduct credits, they can lose them for almost any reason. It's up to the whim of the individual prisons, including the wardens in private prisons around the country. There's no certainty there that I think our clients can rely on.
We're not really going to be involved with private prisons around the country.
Pardon me?
So we're not really going to be articulating a rule for private prisons around the country. So again, I invite you, counsel, to focus your attention on this case and this state.
I am those. We have prisoners in private prisons around the country, Your Honor, and those wardens would be deciding what kind of good conduct credits our prisoners
California
get.
prisoners are
California
being housed
prisoners.
in other.
Absolutely, yes, and
But
and
they
it's
would
very
be-
uncertain.
They would be, obviously, those California prisoners who are in prisons in other states would certainly be protected by the rule that you are articulating here. So I understand that to be the point that you are making.
That's the
and I
point I'm
take that
making.
point.
The point on elderly parole, my main problem with the elderly parole hearing is that when an adult offender who's had the opportunity to be an adult, to make choices, to make adult choices, maybe has a family, maybe has a wife, commits the exact same crime and receives the exact same sentence, or maybe receives a 250-year sentence, after 25 years, that adult gets the opportunity for a parole, where my guy has to serve an extra 20 years before he gets to that point. That, to me, seems like the opposite of Graham. My guy's getting a decades longer actual term, actual time served, and his entire adult life before he even gets the opportunity to have a parole hearing. I don't see how that comports with Graham at all. And then there's also issues with the program itself that don't say anything about taking in maturity and lack of incorrigibility and so forth. They need to be entitled to an actual juvenile parole hearing that takes those matters into account. And I will hand this over to Mr. Kessler.
Thank you, Ms. King.
Thank you, Your Honor.
May it please the court. I'm William Rodriguez's attorney, Daniel Kessler. The issue here, as the Attorney General addressed, is the idea that the Attorney General is espousing here is that you can, when it's sentencing a person like my client, it is constitutionally acceptable to take actuarial tables from the Caballero footnote number 3, look at the vital statistics records, figure out how long that person is likely to live, and then say, okay, you're going to live, the Attorney General is saying 77 years. I believe the briefing had 76.2 years, but it's going to live somewhere in your mid to late 70s. Therefore, a sentence right up to that date, even on that date, right, even 0.2 years left to live is constitutionally acceptable, this categorical approach. But when you read Graham and you read these cases, the language is much more emotional. The cases talk about fulfillment outside of prison walls, the chance for reconciliation with society, the chance to become contributing members of society, the prospect, and this is your court, the Caballero, saying the prospect that as the years progress, juveniles can reform deficiencies and become contributing members of society. A young person who knows, was told, okay, we're going to sentence you for the most terrible crime, and we're not saying that our client's crime was not terrible here, but they are juveniles and they're subject to different rules. So when I say to my client, okay, what we're going to do for your sentencing hearing is the court's going to look at a vital statistic record, figure out how long you're going to live, and then he could pick some date up till that point.
Okay, I get it that you don't like the categorical approach.
Okay.
Okay?
Okay.
So let's say that, let's just put that to the side for the moment. What should we do here? What should we tell the trial court to do here?
The number is what I believe the Attorney General is asking about, that we're asking about. What is the right number? That's the difficult.
Well, no, I'm not asking what the right number is. I'm asking what the right alternative is. Should we say to the trial court, pick a number and just impose that sentence? Or should we say, follow the statute, but require that there be a parole eligibility hearing at a certain point? Because those are two very different alternatives.
I understand. Because
So which
the
one?
statute that you're talking about, 667.61, mandates consecutive terms. And so when you stack all the consecutive terms, our clients were looking at much more than what would be their expected life. And so, but you can't do that. So the question is how long should they be in prison before they have their first meaningful opportunity to demonstrate reform and rehabilitation.
Sounds to me like you're talking about a parole eligibility.
Exactly.
Okay.
Exactly. And so at what point do you get that or those chances to demonstrate you've matured and reformed in your life as a juvenile? And as the court has talked about, this is a moving target, because as we're sitting here preparing for oral argument, I get an overnight package from the Attorney General, and boom, all of a sudden we've got all these new credits issues and everything's changing. So the idea that this could go back to the judge with the moving targets, as the Court of Appeal said, 50 years to life for my client, 6 years for Attorney King's client, is too long. That doesn't provide a meaningful opportunity to demonstrate reform and rehabilitation. They need to have their first chance for parole before that, because they'll be elderly. And we don't see that the Graham and Caballero tests, the Graham and Miller cases meant elderly, geriatric parole, parole in geriatric. That doesn't give the child hope. Any incentive, if you tell a 16-year-old.
Listening for what the solution should be.
Okay. So our proposal was that it go back and that the court follow 3051. And I understand that the legislature has excluded our clients from that. I understand that.
So you would say the court should impose a requirement of a parole eligibility hearing after 25 years. That's the
40s.
solution you're going
correct,
for here.
Your Honor. Thank you. Yes, that's what I would propose, that in their 40s, because that gives the person some hope, some idea that they can reform, some future. And by most understanding of most people, average person expects they're going to live till their 40s. The average person that's going to spend it in prison doesn't expect, if you're going to be locked up till your 70s. You tell somebody you can have your first parole hearing if you're good at 70 years old. That doesn't give a child much hope. It doesn't offer any opportunity to.
Can I ask you, is
Yes.
your rule, though, something that Justice Kriegler was getting to? So does the trial court then resentence to 640 years plus a parole hearing in your 40s? I mean, does the court comply with 667.61 and stack as required all of those mandatory sentences and then impose the hearing in the 40s? Or is it a 50-year to life sentence, which is categorically unconstitutional, therefore it requires now a hearing in their 40s?
I think that it's a categorical sentence when it's too late, when the first opportunity for parole is too late, and provide for their first parole hearing in their 40s or 25 years. Mm-hmm. And that would satisfy whatever you call the end result. If you think about it, if you tell a defendant, look, you're looking at 100 to life, 40 to life, 50 to life, there's life at the end. 640 is life. I mean, by any metric that we use, 640 is life. So what I understand that question, I think it's a matter of 6 of one, half dozen of the other, in a way. As long as the person has the opportunity, a meaningful opportunity to demonstrate maturity, rehabilitation, and so on, reformation. If the idea, by the way, and I wanted to point this out before my time runs out, is that if you give a child, say, 25 years to life, you say, no, we can't do that. In this case, because these people are ineligible for 3051, we can sentence them to up to whatever their life expectancy date is and give the parole hearing any time before that date. So then, say it stands at 50 to life, and my client is cellmates with Mr. Franklin. And Mr. Franklin, who killed somebody, who murdered somebody, is in the cell, and the prison officials come in when he's 41 years old and say, come on, Mr. Franklin, you're going to have your first parole hearing. Under the 50-year rule, my client would have to wait 25 more years in prison for his chance to have the same type of parole.
Could I ask you, if we're going to, I'm not suggesting we do this, because of other prudential considerations that I suggested in earlier comments. But I'm still a little perplexed why you and your friend on your side insist on the 25-year mark simply because it's one that the legislature has already rejected, and it puts us in this very awkward position to directly countermand the legislature. What would you think of a rule that just said no later than at 50 years of age? Balancing all the considerations, which is to say, balancing the consideration that it's longer than a 25-year sentence, thereby respecting the legislature's judgment that these are very serious crimes that deserve additional punishment, balancing the consideration that it's an age at which people might deem much of adult life to be consumed, but by no means all. By no means all, right? And it's a lengthy sentence. It would be 33, 34-year sentence for these juveniles. And it's not quite, it doesn't raise the elderly parole problem in the sense that the differently situated defendants, the difference between someone who served 25 years beginning at age 35 versus someone who started, as your clients would, at age 16, 17 years old, the problem of the unequal treatment would be mitigated somewhat by that rule. So I mean, if you had to come to some kind of arbitrary line drawing, I just don't know why we do it at 25, as opposed to something like, no later than age 50.
The reason,
or if you like the age 50, you don't like the age 55, but if others like the age 55, we could say 55. But in other words, something like that.
the reason, Your Honor, I chose, and I guess you could say we chose the 25-year rule because it was the legislature that was asked to devise a constitutional solution to come up with a number that's consistent with Graham and Miller and so on, and they did. Now, I understand they excluded our clients, and I give you that, but they did come up with a response. The statute was designed to establish what's in the legislature's view is the appropriate time to determine whether an offender has rehabilitated or gained maturity so that he or she may have a meaningful opportunity to obtain release.
But even in the way you've just put it, counsel, it sounds like you're acknowledging that that's not the only solution. Far from it.
I'm sorry?
It's not the only solution.
The 25
what I'm trying to say is, even the way you're responding to Justice Liu, it sounds like you're acknowledging that that is not the only solution to come up with a constitutional scheme.
Well, the 25 years being the...
Correct.
I understand there has to be line drawing, and I certainly understand this court's concern of stepping on the legislature's toes and saying, well, we understand you excluded sex offenders, but we're going to throw them back into the mix. But this court must find a constitutional sentence. The legislature determined when it would be appropriate. And in the idea that my client has to wait 25, if we go to the 50 years, or even Your Honor's suggestion of 50, and Mr. Franklin then at 41 gets taken out and gets to go have his juvenile parole hearing, and my client has to wait 9 more years. There's one point I want to read, and one more quote, and this is from Graham. It says, defendants who do not kill or foresee that life will be taken are categorically less deserving than the most serious forms of punishment than are murderers. So Graham, although our client's crimes were very serious, says that our client's crimes are categorically less deserving of punishment than are murderers. And so that's where I'm coming from here. And that's why I'm coming back to the idea that if it's just awkward, and the word awkward you used, it is awkward all the way around. To come up and say, Mr. Franklin shot a kid dead, another child dead, he can have his at 41. Our clients didn't shoot anyone, can't, have to wait a period of years, and under the Attorney General's analysis, have to wait 25 years before they have theirs. That contradicts the constitutional language in Graham, that them being categorically less deserving of the most serious punishment.
Of course, Franklin did not say that 25 was the outer limit. Franklin did not say that 25 was the outer limit.
No, that's correct.
It said
Did
that,
not
of
say.
course, it's a constitutional sentence, but it's not the outer limit.
Right, I agree. Franklin said 41 years provides for a meaningful opportunity. And that's why I come in advocating for the 40s, because it makes sense. I think once you get into the 50s, I think a child sees, when you add 10 more years on there or so, I think that to a juvenile still takes away the idea of hope to rehabilitate. And it takes away the idea that they're going to go into prison and they're going to have to choose how they want to behave. Obviously, we all want them to show reformation and maturity and everything else. But if you're looking, and I'm just speaking as imaginary child, teenager, who's looking at spending these children don't see that 60s isn't death. They don't see that even late 50s isn't death, or even 70s isn't death. They see, okay, I'm going to die in prison, and so I might as well run with the bad crowd or fix myself in this fashion. Because what's the point of reform? What's the point of demonstrating reform and maturity? I might as well just stay here for my life and fit in. And that's what we don't want to happen. That's what the courts talk about, the change, the children that grow and change, and so on. So I also would take issue, and I think this court's addressed it, with Caballero providing a test for all cases. It was a footnote addressing one simple issue, which was, in that case, whether somebody would be expected to live to 126 years old. The Attorney General's idea of using that in every case does implicate gender and sex and race, because those statistics include race. So if you take his proposal and you say, okay, a 77-year sentence to life sentence for a female, a white female whose life expectancy is 80 years, it'd be constitutionally accepted. The same sentence for a male would not, because they're only expected to live to 77 years or 76 years. So there is gender and racial disparity in those statistics. Thank you. Thank you very much.
Thank you, Mr. Kessler.
Mr. Roddick, are those regulations in place now?
Yes, they are, Your Honor.
And is it the Attorney General's position that those regulations are valid?
Yes.
There's no question that about the Attorney General challenging any of the regulations you've cited to us?
I am not aware of any challenges that our office may bring.
Thank you.
I would like to address a comment made by both of my friends, and that is simply this, is that as compared to persons who commit murder, their defendants would receive an extra long term. That's not before the court today. That's a question for the Court of Appeal to perhaps address under a gross disproportionality analysis. But it's not the question for the court to answer today regarding a categorical ceiling on a sentence. Whether or not it's disproportionate is a whole separate matter, as Graham very, very well made clear.
And it might, and an as-applied evaluation of that question might depend, for example, on whether the murder was a second-degree murder with a reckless disregard as opposed to a concerted series of sexual assaults over a period of time.
Precisely, Your Honor. And the legislature has made the policy choice. These are policy decisions for the legislature. The legislature has told us sexually violent predators, not simply sexual offenders, but predators like the defendants, are more difficult to rehabilitate, and they require greater time to rehabilitate. And that's why the legislature has set up a variety of schemes, such as the sexually violent predator law, because we recognize these people require longer time to rehabilitate. That's a question of policy for the legislature, and it's not a question before the court today. Before the court today is simply the question, what is the categorical limit that can be applied? We know from Virginia versus LeBlanc that it would not be irrational or unreasonable for this court to conclude that 60 years old, as a matter of elderly release, satisfies Graham. We know that much. And so Justice Liu, with respect to the 50 or 55-year rule, they're arbitrary, and those are questions for the legislature. And the legislature has declined to enact those rules as to these defendants. And the legislature has asked us and this court to define a rule at when they have still hope, but that they have not been given an LWOP. And that's the sole question before the court today. And as long as it's not the functional equivalent of a death sentence, then they satisfy Graham. And there's still possibility for other Eighth Amendment review under a gross disproportionality analysis in specific cases. But the question of whether or not it satisfies Graham is an entirely separate matter.
If we reverse these sentences, what would you have us do?
And to Justice Corrigan's similar question, I believe that Caballero sets out what we should do, and that would be to set a term that a parole date that is within their lifetimes, and that is the date that falls within their life expectancies. It's a rule that comports with the doctrinal underpinnings of Graham, and once again, it's not necessarily the last word on Eighth Amendment analysis.
And how does the rule that Justice Liu proposed not do that?
Well, frankly, Your Honor, I believe that Justice Liu would perhaps, and I don't mean to speak for the justice, but perhaps he would acknowledge that 50 or 55 is not the same as a death sentence, that what we're doing here is we're taking an arbitrary number that has no doctrinal underpinnings under the High Court's Eighth Amendment jurisprudence. And so we're taking Graham and we're unleashing it from its moorings.
I would disagree that it has no doctrinal underpinnings. I mean, it depends on how you read the case, of course. I mean, there are other courts, of course, that have rejected 50-year sentences as not in compliance with Graham in similar situations. But I guess I'm asking you, the question about the question of guidance, because sort of, if we are skeptical about the length of these sentences, it does present a bit of a conundrum. What we're going to do next. And in light of what you know about what's going on in the regulatory and legislative environment, I guess I would be interested to know what the Attorney General's office thinks would be the best course ahead. We could remove a lot of uncertainty and enable everyone to get on with their lives. Of course, it's arbitrary. I mean, you pick any number out of a range of numbers, and it's going to be arbitrary. But arbitrary doesn't mean it's unreasonable, right? Against the values stated in Graham. 50 years doesn't strike me as unreasonable. 50 years old doesn't strike me as unreasonable against the values stated in Graham. It may not be a perfect number, maybe 52, 55, whatever. I mean, we could debate that, but it's not an unreasonable number, and it would provide a number of virtues, which is that it would just, clear up for everybody what to do, and victims, defendants, everybody could have some finality, and we wouldn't have to continue to debate this.
Well, then I would respond that we have that rule with 60 years old with the elderly parole period, and that rule has been upheld by the United States Supreme Court. If there were to be a rule, then 60 years old, which, by the way, is the rule that California is applying.
Have us wait, in other words, to see what the pending legislation, for example, would bring.
I don't think it's necessary to wait for that because we already have the scheme that's been set out pursuant to the
we have only a 2-page memo about that scheme. I mean, it's very thin read to rely on.
Indeed. But I suppose that one way or another, we will know within the next week or 10 days. If there are no further questions, I would urge this court to remand the sentence, to overturn the categorical rule announced by the Court of Appeal, and to remand for further proceedings to consider the remaining claims in the appeal.
Thank you. All counsel, matter stands submitted.
Thank you.
Calling the matter of the People versus Jean-Pierre Rices, we welcome the Honorable Gilbert Nares, Associate Justice, Court of Appeal, 4th Appellate District, Division 1, sitting on assignment.
Good afternoon, and may it please the Court. Cliff Gardner appearing for Appellant Jean-Pierre Rices. In accord with my focus letter to the Court, I'd like to focus my remarks today on, in particular, two issues. The first involves the trial court's refusal to discharge 2 jurors for cause, and the second involves the trial court's answer to the jury's question in connection with Exhibits 65A and 65. Time permitting, although it rarely does in my experience, I'd like to address a third issue as well, the free talk issue. But I suppose we'll take that as it comes. So turning to the first issue, the trial court's refusal to discharge 2 jurors for cause. The Attorney General and I agree on the basic facts, and as to this issue, that's just about all we agree on. And that is there were 2 jurors they filled out their juror questionnaires, and 2 jurors said that they believed blacks were more violent than whites in answer to question 53 on the questionnaire. Defense counsel moved to discharge them for cause on 2 separate occasions.
And Mexicans.
I'm sorry?
I thought excuse my voice is hoarse today.
Yes.
I thought he said blacks and Mexicans.
Yes, one juror said blacks are more violent than whites, and the other said blacks and Hispanics and people in prison gangs, or people in gangs, I'm sorry. But given that my client is black, the really relevant portion is that both of these jurors in their questionnaire said blacks were more violent than whites. Defense counsel challenged them both for cause on 2 occasions. The trial court denied that challenge, and counsel used his peremptory challenges to remove those jurors. And the Attorney General and I disagree on 3 points, and the Attorney General suggests and makes 3 points in their argument. First, they say the issue isn't preserved. Second, there's no error to begin with. If it is preserved and there is error, it's harmless. So I've pretty much done everything an appellate lawyer can do wrong. I've raised an argument that's wrong on all 3 counts. And I'd like to address each of those counts and make an additional comment, if I may. The first position of the Attorney General is that the issue wasn't properly preserved by defense counsel. And to their credit, my colleague from the Attorney General's office concedes that there are 3 factors in assessing whether this issue is preserved. The first is, did counsel use the peremptory challenge to dismiss the juror? They agree that happened here. The second is, did counsel use all his or her peremptory challenges? And they agree that that happened here. And it's the third element that we have disagreement on, because the case law requires that counsel express dissatisfaction with the jury as seated. And the Attorney General suggests that didn't happen here. And the Attorney General correctly points out that after the for-cause and hardship process was done, defense counsel made a motion, and this was before the jury was actually seated. Defense counsel made a motion to renew his for-cause challenges for the court to reconsider, or for the court to give additional peremptory challenges. And the Attorney General points out, I think correctly, that can't possibly be an expression of dissatisfaction with the jury as seated because the jury hasn't been seated yet. And that makes sense to me because the jury hadn't been picked yet. The problem is that the record doesn't end there. The record goes on. The court picks a jury, and before they are after they're all selected, defense counsel renews his motion. Says, okay, now that we've picked a jury, Your Honor, I need more peremptories because of all these for-cause challenges that you denied.
So your essential position is that the Attorney General's reading is a little too crabbed because at the end of jury selection, as you described it, Mr. Gardner, when defense counsel says, now I need more challenges, the inescapable conclusion is he wants more challenges so he can challenge the people who the court, in his opinion, wrongfully refused to excuse. To use a phrase in great currency this afternoon, that's the functional equivalent of expressing dissatisfaction with the jury.
Yes, exactly, Your Honor. Not only is it the functional equivalent, it's what this court has always recognized. This is one way you express dissatisfaction with the jury is by asking for more peremptories. I mean, let's take a step back and say, okay, let's say the court had granted peremptories and defense counsel didn't use them. I mean, what position would there be? The defense counsel's asking for peremptories. The reason counsel asked for additional peremptories is because he's not satisfied with the jury. You don't ask for more peremptory challenges if you're satisfied with the jury.
Did he say he's satisfied with the jury?
No. There was no colloquy on the exact talismanic language, Your Honor, I'm not satisfied with the jury. There was, Your Honor, I need additional peremptory challenges.
Never required, have we, automatic talismanic
No.
language?
And that, I think, is the point I tried to make in the briefing, is that in many cases, this court has looked at the absence of a request for additional challenges and pointed out you didn't ask for additional challenges, therefore you didn't express dissatisfaction with the jury. So that plainly, at least historically, has met the requirement of expressing dissatisfaction with the jury. I think the issue is preserved. So then we turn to the merits. The Attorney General's second position is that, okay, let's say it is preserved. There's no error here. And I have to say, I don't have many remarks to make on this, but I have to say that in light of the Supreme Court's recent decisions in Buck versus Davis and Pena-Rodriguez, Buck versus Davis was the case that said you can't really, it would be patently unconstitutional for a jury to consider race in the future dangerousness calculus. And Pena-Rodriguez was the case that said we're going to override the no impeachment rule because we're going to allow impeachment when racism is at issue in the jury room. In light of those cases, I don't understand why the state is tacking so close to the wind on this one. I have my client is black. 2 jurors said they believe blacks are more violent than whites. Admittedly, some also added Hispanics into the calculus. The jury was going to be asked to make a judgment as to whether my client should live or die. One of the factors in that calculus is future dangerousness. If jurors who believe blacks are more dangerous than white aren't substantially impaired in making that calculus, I don't know why question 53 is on the questionnaire. As I was preparing for argument last night, I thought, what answer could someone give other than blacks are more violent than whites that would get you kicked off the jury to question 53? That's what it was designed to elucidate, to find out. I mean, one of the interesting things about this case is that the questionnaire actually worked. We found out that there was a problem in the jurors. And yet, when defense counsel raised a for-cause challenge, that was denied. So I think plainly there was error in the denial. And that brings us to, I suppose, the comment of the first lawyer that argued his case was there's the rub of the case. And here's where the rubber meets the road on this one, I think, is the question of prejudice. The Attorney General points out and relies on this court's decision, People versus Black, to argue that there was no prejudice. And I don't disagree that, in fact, counsel didn't meet the requirements of Black here. So it's my job to persuade you as to why I think Black shouldn't apply. And the reason is pretty simple. Black was decided in 2014. This trial was in 2009. At the time of this trial, Black wasn't the law. Counsel could not have known he was supposed to make the motion that Black and Yeoman required. And I say Black and Yeoman because Black adopted the rule from Yeoman, a 2003 case. In the absence of knowing that counsel had to make a motion as to a seated juror, there's a real problem with applying Black to this case. I think one of the interesting points about this case is to look at the Black decision. And Black talks about the Court of Appeal decision by Judge Wilhite in People versus Baldwin. And I was going to steal this, and then I decided I better fess up and make sure that you knew it was from Judge Wilhite. Judge Wilhite does a really good job of explaining what the difference is between Black on the one hand and the Bidiger rule on the other hand, which was the resolution. And what Justice Wilhite says is that in the pre-Black days, when this case was tried, in order to obtain a reversal, you had to show that the trial court erred as to a ruling in connection with a juror that defense counsel actually discharged. That was the relevant inquiry. Under the Black case, Justice Wilhite says, the focus is entirely different. The focus is on the jurors that are actually seated. It's a 180-degree shift. And without knowing that shift, to retrospectively say defense counsel in this 2009 case was required to apply this 2014 principle is, I think, unfair. It calls, to my mind at least, I think it was the comment of the late Judge Alarcon when he said it smacks of the brutal absurdity of commanding a man today to do something yesterday. And that, I believe, is what the Attorney General's reliance on Black does. If there are no more questions as to that issue, I'll move on to what I'll call the Exhibit 65 and 65A issue. And that is, and the good news is that as to this issue, there is a much greater agreement between the Attorney General and myself. The basic facts, again, are undisputed, and that is that during Miller's cross-examination, the prosecutor referred to and marked Exhibit 65 and 65A in front of both juries, the Miller jury and the Rice's jury. During the discussion on exhibits that followed after the close of evidence, the trial court said to the prosecutor, The people are offering all of the exhibits that have been referred to and marked. Is that correct? The prosecutor. Yes, Your Honor. 65 and 65A, of course, had both been marked and referred to. And the third point, sort of an undisputed fact, is that 20 minutes into jury deliberations, the jury came back, the Rice's jury, and said, let's see Exhibit 65 and 65A, can we? And the trial court answered that question in the absence of counsel and said, no, you may not. That's not before you. And the Attorney General, I think very much to their credit, concedes that that violated my client's right to counsel. And so the question, again, where the rubber meets the road on this one, is harmless error. The state argues it's harmless. And they do so for two separate reasons.
Since you were so imprudent as to take a drink of water, I just want to make sure I understand the factual framework.
Sure.
So you are taking a position that the admission of 65 and 65A would have been erroneous as to Mr. Rice's?
No, Your Honor, then I have plainly misstated, and I'm actually glad I got the water then.
Well, it could be that I'm just delusional, but I want to make sure that I understand your factual predicate.
Sure. It's not the admission of 65 and 65A. That's entirely appropriate. What was inappropriate was the court telling the jury that it wasn't before them, the Rice's jury. In fact, I believe 65 and 65A was before them.
Okay.
Now,
Thank you for the
Miller was cross-examined, correct?
He was.
And is there anything relevant in the physical exhibit that was not covered in the oral testimony?
Well, it's true that the prosecutor went through the physical exhibit with Miller at the very end of his cross-examination. And so I suppose the question that Your Honor is getting at is, let's say the court did err in excluding the actual exhibit. The testimony was before the jury anyway. I take it that's where Your Honor's headed. And I think that suggests a legal sophistication in the jurors that they do not have. When they come back after 20 minutes, Your Honor, and they say, let's see 65 and 65A, because that will give us some context for these questions and answers. And the judge says, those aren't before you. I think what that tells any reasonable juror, okay, that part of the testimony isn't before us. We can't consider that. I don't believe a juror is going to have the legal sophistication, much less 12 jurors have the legal sophistication to say, okay, the exhibit itself isn't before us. And that may, absent the exhibit, we may not really be able to understand the questions. But the answers about 65 and 65A, we're fine with. I just don't believe that's a reasonable inference we can make about what jurors would have thought.
Is that part of your denial of the right to counsel argument, in the sense that if counsel had been present, they could have requested that the court, at the very least, clarify that aspect of it?
Absolutely, Your Honor. And that's, there are two separate parts to the harmless error inquiry. One is, was the court's answer wrong? I think it was for a number of reasons, but at the end of the day, or here at the beginning of the day, what I would say is that it doesn't matter, because the vice is that counsel wasn't even allowed to make the argument. And if counsel had been alerted to the question, the fact that 20 minutes in to the jury's deliberations, they asked to see this exhibit. And let's put the exhibit in context, because Miller came and testified that, in fact, my client forced him to do the crime at gunpoint. He was afraid to walk away. He was going to get shot. So there was aggravating components to Miller's testimony. And, in fact, the DA said this is an aggravant, and the trial judge said, you're right, it is. And the DA introduced this evidence to impeach Miller. So it was plainly relevant to the jury's penalty phase calculus, since it undercut Miller's testimony about an aggravating factor. And absent counsel being there, the court just saying this isn't before you, I think it was wrong. I think it was before them, because the prosecutor moved in all the exhibits that had been, quote, marked and referred to, and this was both. But even if it's ambiguous, even if there's a slight trace of ambiguity, the problem here is that counsel wasn't allowed to make the argument. And his argument, I suspect, would have gone something like this: Your Honor, this was aggravating evidence that the prosecutor elicited in front of the Rice's jury. This evidence impeaches that. The state offered the exhibit. I didn't object. What possible argument could the state have for keeping this out? And there is no answer to that. This was the state's exhibit. So this certainly would have gone to the jury, which brings us to the state's alternative harmless error argument.
Is there a distinction between, when you're impeaching with a prior inconsistent statement, is there a distinction between being able to confront the witness with the fact that a statement was made and having the document itself be admitted into evidence? Because there are a number of rules in which the content of a statement can be relied on in open court, but the document itself is not customarily admitted.
There may be, but I'm hard-pressed to see the distinction here, Your Honor, because at the end of the day, when the jury says, can I see the exhibit, there had been no objection to this. I don't know that the state could base an objection on the dichotomy you've just suggested. I don't see that as happening, and perhaps in a few minutes I'll be educated. I often am in these chambers. But I don't think that would be the basis of any solid objection by the DA to say, yes, I offered this piece of evidence, Your Honor. It does impeach the witness, but I'm objecting to the jury that considering it.
The document that I offered.
Exactly, exactly. It seems like there's no argument that the DA could have made to keep this out of evidence. And that's the vice of the right to counsel violation, is that counsel couldn't make the argument for the court to rule on. And that brings us to the second harmless error argument that the state has raised. And in the alternative, the state argues that even if this would have come before the jury, it would make no difference. And I understand that argument, and my colleague from the Attorney General's office does a good job of summarizing the aggravating evidence that was before the jury in their argument that they have, in fact, carried their burden of proving beyond a reasonable doubt that impeachment of Miller would have made no difference. And I understand I'm not here to tell this court or suggest that this wasn't a case with serious aggravating evidence. It was. But for three reasons, I think that the Attorney General's suggestion that it can carry its heavy burden of proving this constitutional violation harmless beyond a reasonable doubt must be rejected. And the first is that let's take a look at the jury deliberations. Not 20 minutes into deliberations, the jury asked for this specific exhibit. They didn't ask for any other, I'll call them defense-friendly exhibits in their deliberations. It was the first thing they asked for. It was the only thing they asked for from the defense, and they didn't get it. So regardless of what importance we as post-conviction counsel may place on it, the jury clearly placed importance on it by asking for it, as they did so quickly. The second point is that I concede this was a case with aggravation, but this was not a case without mitigation. And I know this court has great familiarity with capital cases. I've been doing them for some time as well. And we often see what we see in this case, at least intellectually, we see a case of abandonment of a child. But it's rare, at least in my experience with capital cases, that we have direct evidence of the abandonment, as we had in this case. There was a powerful defense narrative from Diane Northup. And Diane was the witness who was at the Jack-in-the-Box when my client was 4 or 5 years old. And she saw my client's mother, literally, she saw the moment of abandonment. She saw my client's mother screaming, get away, calling him stupid, throwing rocks at him and throwing a beer can at him, while my client was 4 and 5 years old, talking to his mom, saying, Mama, please, I want to go home. So this wasn't a case without a mitigating narrative. There were other elements of the mitigation, but to me they pale by comparison by that eyewitness narrative that we so rarely have in capital cases. And the third point I'd make on the question of whether this error is harmless is to point out that Miller was a very important witness for the prosecution in the penalty phase. The prosecutor relied on Miller's testimony and told the jury that, in fact, if there was nothing else but the statements that Miller had given the jury, that was enough to sentence my client to die. The impeaching evidence, which suggested that Miller was falsely attributing culpability to Mr. Reisis, directly undercut Miller's credibility as a witness. And to suggest now that Miller wasn't important to the state's case, I think does a disservice to the record. I don't think that's what the record supports. Apparently, I do have time, unless there are other questions, to turn to the third issue. This is a first for me. So I'd like to make a brief comment on the free talk issue. And then, again, the facts are relatively undisputed. Miller, after his arrest, made a statement to police. That statement was properly disclosed to the prosecution. Some months thereafter, in fact, more than a year after, he had what's called a free talk. That's where he doesn't get his rights so that the state can't use that in their case in chief. And he gave the police a very different version of events and the prosecution a very different version of events. The prosecution asked the court in an in-camera hearing if they could keep that a secret, if they didn't have to disclose it under 1054.7, and the court agreed. One of the points the prosecution made fairly, and I think entirely in good faith, was that they weren't going to call Miller as a witness. of course, things changed at the penalty phase, and Miller was called as a witness, albeit by the co-defendant. But no one told defense counsel that this free talk had been made. And of course, the defense position is that someone at some point should give the defense the statement, the several-hour statement that Miller had made to police, because defense counsel has to cross-examine him in the penalty phase. And the state's position, briefly, is that no one really had the responsibility. The trial court didn't have the responsibility, and the prosecutor didn't have the responsibility to do this. And I will say I don't have a substantive point to make. I will just say we are at loggerheads on this. It is surprising to me that in light of the Eighth Amendment need for reliability, in light of the Due Process Clause, in light of 1054.1, that this could happen. That in fact this person could make a several-hour statement to police, and it's not disclosed to defense counsel, who has to make the decision, should I cross-examine or not?
And in this case, counsel, what is your position regarding the harm that occurred as a result?
Well, I guess that is where the rubber meets the road yet again. If counsel had been given that statement, I think the trial changes in a number of respects. Now, of course, the state's position is we don't know exactly what defense counsel would have done, so we need to push this into habeas. And my position is that we know what reasonable counsel would have done, and that's the test. It's not what defense counsel would have done in this particular defense counsel. It's what reasonable counsel would have done. So let me try to explain what I think reasonable counsel would have done. I think what reasonable counsel would have done had he seen that free talk is he would have known that Miller was going to testify, first of all, because in that free talk, he gives the duress theory. And at that point, defense counsel says, wow, this isn't the original statement he gave, where he was entirely culpable. He's now got a very different theory. If he wants to get out from under this offense, he's going to have to testify. So Miller's going to testify. Okay, what do? I think what reasonable defense counsel does is first make a motion to that the Rice's jury isn't present for Miller's testimony. And defense counsel does do that, but he does it at this point during the cross-examination of the DA, and the court says, well, why is this coming in so late? Why are you making this motion now? And I think the reason why he's making it now is because he didn't have the free talk to make it earlier. So that's the first point. I think he makes the motion to keep Miller's testimony out. And the motion is premised on principles of Brady and Giglio and Pugh and the Eighth Amendment that requires reliable information at a penalty phase. And the protections of Brady and Giglio and Pugh, which don't apply to this witness, because after all, it's not a state witness, mean that his testimony may not have the indicia of reliability that we normally rely on at a penalty phase. So I believe he makes that motion. Now, he could lose that motion. What would he do then? I think what he would do then is he would orient his jury voir dire, his questions, to say, okay, now I've got to face this piece of evidence in the trial. How do I pick a jury that's going to be better for me in light of what I now know the evidence to be? Because let's face it, one of the responsibilities of trial counsel in picking a jury is you pick a jury with an eye towards the evidence that's coming in against you and that you know about. So I think he both the jury questionnaire changes, the jury voir dire changes. Does the opening statement change? I think it does. If you know this evidence is coming in, this is powerful evidence, you're going to have to foreshadow it in your opening statement. Does it change the cross-examination of Miller? Remember, as it happened, as in the real trial.
Was there anything in the free talk favorable to the defendant?
Well, aside from the fact that it's a completely different story than he told police and can be used in that way, the only thing I think that was favorable was that he identified someone else as the driver, and so there was yet a separate inconsistency. And that was properly turned over by the police, by the prosecution, that piece of evidence. So I think there's ultimately a number of things. The trial was completely different had this been turned over. And it just mystifies me that there's some principle that says the only people that knew about this in court were the trial judge and the prosecutor. And both of them were permitted to just say nothing as Miller was called to testify. So, unless there's questions on that issue, I'm prepared to submit the case pending my rebuttal.
Thank you, Mr. Gardner.
Thank you, Your Honor.
Good afternoon. May it please the Court. In addressing the last issue that Mr. Gardner discussed, the free talk, I take issue with his categorization that this duress theory was not before the defense until Mr. Miller took the stand.
Could you define free talk for me?
I think free talk just means an interview. I think in this context, this particular district attorney's office and maybe others categorize a free talk as something where a co-defendant is questioned, they're assured that their statements won't be used against them in the prosecutor's case in chief.
Is his defense counsel there or an attorney there?
Yes. In this instance, there was.
So the person being interviewed, who is a criminal defendant, has his lawyer and other people assisting in his defense present during his own interview.
That's correct, Your Honor. And in this particular instance, it was held in contemplation of maybe the parties could work out an agreement whereby Mr. Miller would cooperate with the prosecution and maybe get some benefit in exchange for his truthful testimony. Ultimately, no agreement was reached in this case. But in looking at the contents of the free talk and the contents of the police interviews that were given and provided to defense counsel, this idea of a duress could have been no surprise. In Mr. Miller's second interview with the police, which was provided, he explained to the police that he wanted to walk away from the robbery, but he didn't want to risk being shot by Mr. Rices in the process. He felt pretty positive that had he turned away from the robbery, Mr. Rices would have shot him. So this idea that when Mr. Miller took the stand for the first time, it was the first moment that the defense could have known that the duress defense was in play is simply not borne out by the record in this case.
Let me ask you the question about if they knew this transcript existed, and it comes as a complete surprise to Mr. Rices, whereas when he could have had the conversation transcribed and considered his strategy and figured out what he was going to say to the jury, and I think what he would anticipate would be mitigation, and the fact that it was inconsistent from what Mr. Miller had said previously in any part, that would have been pretty helpful for the defense to know right away, wouldn't it have been?
And as respondents said in the supplemental brief, we do believe that it should have been disclosed by the prosecution at the time that Mr. Miller took the stand. So the prosecution should have disclosed that once they were aware that Mr. Miller's testimony was in play, and the reason being that the basis for the good cause to delay the disclosure was Mr. Miller's safety and custody, and once he took the stand and testified on his own behalf, that concern was somewhat ameliorated. But as far as, would this have made some big difference in helping the defense prepare, it would not have. Many of the statements that Mr. Miller made during the free talk were made during prior interviews. And the other thing that's important to note is the context of this case. This wasn't a trial that bore on the guilt of the defendant. The jury was tasked with making a moral determination as to what Mr. Rice's penalty should have been. That being the case, whether or not Mr. Miller stole a pack of cigarettes or didn't really doesn't bear on that decision. Whether or not Mr. Miller was very friendly with the owner of the store versus not doesn't really bear on that decision. But the most important factor that the defense should have known about and did know about was that when Mr. Miller got on the stand, he was going to testify that he felt pressure to do so. And I also do take issue with some other facts that Mr. Gardner has set forth. Mr. Miller didn't testify that he committed this robbery at gunpoint. To the contrary, he said that he was not threatened by Mr. Rice's in any way, and that was consistent across the board with all his interviews. Rather, he just said that knowing Mr. Rice's reputation, he had a gun in his hand. I felt helpless as to what I could do under the circumstances. That's been consistent through every interview. So,
if I understand your position, you are acknowledging that once Mr. Miller was called to the stand, the free talk statement should have been revealed at that point.
Under 1054.1, yes.
But that in evaluating the prejudice question, we should parse the contents of the free talk statement to, at the very least, see what some of those statements were and whether or not other statements that had been disclosed to the defense covered that same topic.
I think that's very important. And one of the bases for the court's decision to delay discovery in this matter on the free talk was the fact that much of the evidence that was included in the free talk had already been contained in other statements as well. So the actual contents of the free talk is very crucial in assessing whether or not there was prejudice in this case, and there were just no material inconsistencies between the free talk and Miller's testimony and the prior statements that were not disclosed to the defense. One other slight point of contention is the fact that the fact of the free talk itself was kept a secret from the defense. If it was a secret, it was a very, very badly kept secret. The prosecution stated on the record twice that he had let counsel know that there had been another statement that basically set forth that there was a different driver that Mr. Miller had already indicated in his prior statements. There's also a portion of the transcript that notes that counsel for Mr. Miller thought that Mr. Ricey's counsel knew that the free talk had occurred. So there are things on the record that do demonstrate that although Mr. Ricey's counsel did not have the transcript for the free talk, and he should have been provided the transcript for the free talk, he nevertheless knew that another interview had been conducted.
Doesn't it seem odd that knowing that, defense counsel wouldn't sort of ask to take a little gander at it?
It is curious. And in fact, it seems that during testimony that was just taken in Miller's case only, Mr. Chambers, who's Mr. Ricey's attorney, sat in for that. And during one of the witnesses' testimony, one of the detectives, he was actually asked about the existence of the free talk. And I believe that Mr. Chambers was in the room at the time. So the fact that this was a secret, I don't believe it was actually a secret, although counsel should have been provided a copy of the transcript. But based on the fact that the jury was tasked with making a moral determination in this case, the fact that counsel may have cross-examined differently, and I will note that counsel didn't cross-examine at all. He didn't cross-examine Mr. Miller at all, and that was likely because all the various inconsistencies throughout Mr. Miller's testimony were addressed by Mr. Miller's counsel in direct examination and quite scathingly through the prosecutor during that cross-examination. And many of those inconsistent points that Mr. Ricey's points to now were addressed by the prosecution. So that's another layer to the prejudice analysis, that these inconsistencies were well addressed in front of the jury, so much so that Mr. Ricey's counsel declined to even cross-examine Mr. Miller at all. Unless the court has any further questions, I'd like to turn your attention to the challenge of the jurors. The people submit that this claim was forfeited, and that is largely a reason of timing in this case. Mr. Gardner concedes that the initial motion for reconsideration was filed before a single juror was even seated in this case, so it doesn't follow that that could have expressed any dissatisfaction for the jury. But when he did ask for reconsideration, that was after the jury was already sworn. So at that point, the court was basically left without any ability to rectify any problem. At that point, the alternates hadn't even been seated yet. So there was simply no avenue that the trial court could take once the 12 had been sworn and the alternate jurors hadn't even been seated yet in order to address any problems that Mr. Ricey's had with the composition of the jury.
Could the trial court have declared a mistrial at that point?
I believe that jeopardy would have attached at that point, and
if the defense was objecting, the trial court could turn to the defense and say, it appears as though my only other alternative is to declare a mistrial, but I won't do that because jeopardy is attached. Do you have a motion?
I mean, that's
really the way that gets handled.
That certainly didn't happen here, and there was no motion for a mistrial by Mr. Ricey's in this case.
I'm just responding to your assertion that the trial court could only throw up his hands and say that there was nothing it could do, and I'm pushing back on that a little.
Well, I think that in an extraordinary circumstance, that could have been something, but that's not really what expressing a dissatisfaction of the jury contemplates. It contemplates the trial court being able to correct any problems with the jury that is before the court. And given the fact that judicial resources are such that...
Doesn't your strict view of the temporal evolution here put the defense in an untenable box? They can't declare that they're unsatisfied before the jury is selected, and yet after the jury is selected, we don't care that they're unsatisfied. I'm lost a little.
I think that it wouldn't be very difficult for prior to the time that the jury is sworn for the defense to ask for, a brief sidebar and make the motion at that point. This has been a rule that's been in effect since this court announced the decision in Crittenden in 1994. Defense attorneys are more than aware that if they want to preserve this claim on appeal, that they need to express a dissatisfaction with the jury, and doing so after the jury is actually sworn and before a single alternate juror has even been seated simply does not suffice to preserve the claim.
Did anyone ask any questions about the answers to the questionnaire?
I'm sorry?
Did anyone ask any questions of the jurors about the answers in the questionnaire?
No, Your Honor. And in fact, when the initial motion to remove these two jurors for cause were made, it was not on the basis of this particular answer to the questionnaire. It was only within the confines of the written motion for consideration. So these jurors actually weren't questioned by defense counsel. The court did not have the opportunity at the time that oral motions to remove these jurors for cause were made. So there is a little bit lacking on the record because defense did not really diligently pursue this avenue until filing a motion the morning before the court was going to reconvene. But just insofar as the actual answers that the juror gave, and there are two jurors, and it is true, they both basically said that I believe one specifically said that African Americans and Hispanics were more likely to be violent, but then they kind of did like a 3 dots and said people in gangs. So that could have been a qualification as to gang membership as opposed to somebody that was having a problem overall with race. The other one did say that they believe that blacks and Mexicans were more likely to be violent, but that people of all races exhibited violence. But the part that saves these answers is the fact that both of these jurors affirmed further down the questionnaire that there was nothing about Mr. Ricey's being African American that would affect their determinations in this case. And while perhaps a fiction, we would all hope that we would not have any jurors that would come in with any type of bias. What we're really looking for are jurors that are able to put aside any bias and decide the case that's before them. And these jurors both affirmed that they would be able to do so. And this court's decision in Jackson is somewhat instructive on that point, where there was a juror that said basically the same thing about the propensity towards violence, also said things that were even more egregious, but in Jackson said there was an equivocal nature to those answers because that juror did say that he would be able to fairly try the case. And that case is on all fours here. Now, with respect to prejudice, People versus Black applies to this case. And the reason why that is because in Black, they refer to the decision in Bittaker as dicta 6 times. They basically discredited that small portion of Bittaker that said that prejudice could be shown if counsel says that he would have excused an additional juror without having to, excuse them for cause. And the reason why Black applies here is because to permit appellant to just make a small showing by saying, I would have excused this juror because he had a nephew in Montana that was a law enforcement agent, that's just not sufficient to actually show prejudice. We have a situation here where there were 3 jurors in the appellant's opening brief that sat on this case that Mr. Gardner says that would have been excused, but that shouldn't be the inquiry. It is whether that juror was incompetent to sit on the trial before it. It didn't put any additional burden on defense counsel in this case, because when challenges for cause came up, he was able to ask that these jurors be excused for cause, but he didn't do so, and that's strong evidence of the fact that these jurors simply were not incompetent to sit on the case. So the people would submit that the prejudice analysis in People v. Black applies. If there are no further questions, I will address the exhibit issue. This idea that the threat as an aggravant simply wasn't present in this case. Mr. Miller, in fact, when we look at the moral task that was before this jury, was not an important witness in this case. He did provide some additional details to the circumstances of the crime, but insofar as what this particular exhibit showed to the jury, there just wasn't anything there that wasn't cross-examined on. The only point that the prosecution was trying to show was that Mr. Miller considered himself a protege of Mr. Ricey's, and that fact was before the jury.
Right, but your opponent makes a slightly different argument, that, first of all, the trial court took this action without consulting with counsel.
Which it should not have done.
Okay. And that there is not a purely speculative possibility that the jury may have misunderstood what the trial court was already improperly trying to convey to them, that you just can't consider the fact that these statements were made at all, as opposed to whether or not you can actually see the document. And that had counsel been present, which he had a right to be, and which Mr. Ricey's had a right to have him be, at the very least that clarification could have been given to the jury.
I don't think that it's speculative to think that the jury would have inferred that because the exhibit had not been admitted, that they couldn't consider the impeachment of Mr. Miller. There was no objection to the testimony of Mr. Miller, that they had been instructed as to what evidence was, which meant the testimony of the witnesses. There was no motion to strike. So I think it's a stretch to say that because the court sent back a note that said that this particular exhibit was not before the jury, that they would have extrapolated from that the testimony of Mr. Miller on this point being impeached was not before the jury as well. Now, with respect to counsel, possibly making a motion to permit the exhibit before the jury had he been informed, that could have happened, and it may have been successful. But the prejudice analysis here really hinges on what did that exhibit show? And that exhibit showed next to nothing. The exhibit was merely a letter from Mr. Miller to Mr. Ricey's, talking about his girlfriend, talking about his grandma, talking about that he was disappointed that people weren't backing him or visiting him in jail. The only relevant part of that letter was before the jury. And so to say that the jury's decision in this case in assigning Mr. Ricey's the death penalty based on a letter that was apropos of really not much, if anything, I think the people have shown, particularly in this respect, that there's just no reasonable possibility of any prejudice because this exhibit was either not provided to the jury, but really more germanely, the fact that counsel was not alerted of the jury's note and then consulted with it. So if there are no further questions, I would just ask to conclude. Your Honors, Mr. Ricey's does not find himself on death row because counsel did not excuse a couple of jurors. He does not find himself on death row because counsel did not have access to Mr. Miller's free talk statement, which was largely consistent with the other statements he had made in this case. And Mr. Rices does not find himself on death row because the jury didn't have an exhibit that was a letter from Mr. Miller to Mr. Rices talking about life in general. Rather, Mr. Rices finds himself on death row because he had a penchant for violent crimes. He had a penchant for armed robberies. And during the course of one of those armed robberies, he laid 2 people on the ground and he shot them in the back of the head. And he demonstrated further cold, callous, and senseless acts of violence when he tried to kill a sheriff's deputy while he was in custody. When those aggravating factors are viewed, even with the compelling circumstances of Mr. Rice's abandonment that Mr. Gardner discussed, there's no reasonable possibility that any error that occurred in this case would have changed the outcome, and we would ask that the court affirm this death judgment.
Thank you, Ms. Butler.
Thank you.
A few points on each of the issues. And I'll start with a comment about my colleague's final comment, because as she did in the brief, she again persuasively talks about the aggravation and then talks about the mitigation relatively briefly. And of course, I did the opposite. I talked about the mitigation at some length. But she talked about there's no reasonable possibility. That isn't the test. The test the Attorney General has to meet is to prove to this court beyond a reasonable doubt that not a single juror could consider this evidence, and we'll talk about the evidence in a minute because I want to make sure it's accurately characterized, that not a single juror could offer a different verdict. And I don't think the state has met its burden here. But let me return to the 3 issues. Let me start with the jury discharge issue. My colleague has accurately told the court that in their juror questionnaires, these jurors also said that, quote, there was nothing about being black that would affect their verdict. And let me tell you why I don't think, I mean, there's a good reason we don't let jurors self-assess whether they should sit. The first part is that at that point in the process, the jurors haven't been informed that future dangerousness is at issue. So they've said that blacks and Hispanics are more violent. But without knowing that, in fact, they're going to be considering future dangerousness, they can't possibly know if the defendant being black will affect their verdict. They can't possibly know that unless they're sophisticated enough to know that future dangerousness is at issue under the California scheme. So the idea that we're going to cede the court's ability to make this judgment to a jury that isn't informed of the relevant statutory criteria for death and abdicate your responsibility to let the jurors decide for themselves, I think is inappropriate.
Is it at all concerning or is it all relevant that at the time the defense had an opportunity to examine these jurors on the subject of their questionnaire, there were no questions about this topic?
It would be if I were making a different claim, Your Honor. If I were making a claim that the error here is that, in fact, there was an inadequate voir dire of the jurors on this issue, then I think the court would be well within its province to say, well, wait a minute, your attorney had an opportunity to voir dire them on this and didn't. So I think that would be a response to the claim. But the claim here is very different. The juror questionnaires contain a prima facie case that there's a problem here. And the question is, without further voir dire to rehabilitate these jurors, should they have been discharged for cause? Now, it's true the defense counsel didn't ask questions on this. Neither did the prosecutor and neither did the court. So the question is, when the questionnaires contain, as I believe, prima facie evidence that there is a racial problem going on and they haven't been rehabilitated, is a discharge proper or required? And I think the answer is yes. Counsel also talked about the Jackson case and said it's controlling here. It is not controlling here. Jackson was a case in which a juror indicated that he had been raised with racial prejudice but had outgrown it. And the court saw that. And even though the juror had said he had outgrown it, the court thought, well, I should voir dire on this. And the court did. And the court listened to the juror's responses, and the juror said he would be fair, and he put that in his background. And the court then overruled a for-cause challenge. And that was challenged on appeal, and this court said, hey, there was questioning on this. We defer to the trial court. In this case, as my colleague's answer to Justice Chin suggested, there was no questioning on this area. There's nothing to defer to. All we have is the rote answer in the questionnaire, which is prima facie case that there's a racial problem here. So I don't believe Jackson at all controls this. I agree that it's instructive, but the Attorney General and I disagree on the instruction this court should draw from it. In terms of Exhibit 65 and 65A, counsel does a pretty good job of suggesting that, yes, Miller may have added additional circumstances of the crime to the state's penalty phase case, but it wasn't much. And I have to urge the court to look at what the prosecutor actually said. The prosecutor looked at those statements that Miller made to police and said, if you have nothing else, that's enough to give him death. This wasn't an additional circumstance in the prosecutor's penalty phase closing argument. It wasn't a tag on. It was the core of the prosecutor's closing argument. And if you undercut Miller, you undercut the core. Has the state therefore carried its burden of proof beyond a reasonable doubt that not a single juror could have reached a different result had Miller been impeached? I don't believe so. And let me talk for just a second about the actual evidence. Counsel suggests that the only relevant portion of that letter was the portion where he says, love you, bro, I'm your protege. And she's right. That is the relevant portion. But contrary to the suggestion, that didn't come out of the blue. There was a reason the prosecutor introduced that. And remember, Miller's jury was there and the Rice's jury was there. And the reason the prosecutor introduced it is because it absolutely destroyed Miller's testimony. In fact, although my colleague suggested it wasn't particularly important, in Miller's case, the prosecutor used this to say to the jury, not only is Miller lying, but he's trying to pull a fraud on the court. That's strong language. I don't think I've ever seen a prosecutor say that before. Accuse the defendant and counsel of trying to pull a fraud on the court. Not my client's counsel, but Miller's counsel. So this was not some passing, oh, it's just about a little bro and being a protege. It was a central part of the prosecutor's attempt to rebut Miller, and Miller had provided aggravating evidence. And finally, let me just one comment about the free talk. My colleague suggests it's harmless because of the prosecutor's scathing cross-examination, end quote, scathing cross-examination. Keep in mind that the prosecutor's scathing cross-examination in front of the Miller jury ended up with a hung jury. So it really wasn't that scathing. Counsel didn't forego cross-examination because he had no questions. Counsel forewent cross-examination because I think he really was lost at this point. He had made a motion in the midst of the prosecutor's cross-examination, hey, get my jury out of here. And the court said, why is this coming in so late? And the reason it came in so late and the reason he didn't cross-examine was because he didn't have the free talk. Unless there's questions on any of the issues, I'm happy to submit it, Your Honors.
Thank you, Mr. Gardner. Thank you, Ms. Butler. The matter is submitted. Stand in recess until tomorrow morning.